Nicholas, privilege of the floor, or?
No, I just did an announcement. Your House appropriations will meet at 7:30 to hear House Bill 195 tomorrow morning.
It's you now. Mr. Majority Floor Leader.
Mr. Chairman, I move the Committee of the Whole rise and report.
You've heard the motion of the Majority Floor Leader to rise and report. All those in favor signify by saying aye. Any opposed? No. The motion carries.
Mr. Chairman,
Thank you, Mr. Speaker. I move the adoption of the Committee of the Whole report for House Bill, Budget Bill number 1.
the reading clerk will read the Committee of the Whole report.
With respect to the budget bill, House Bill 1, the following sections were explained. Section 1, Section 4, Section 6, Section 7, Section 10, Section 11, Section 15, Section 20, 21, 23, 24, 27, 37, 39, 48, 49, 51, 57, 60, 66, 67, 72, 77, 80, 85, 90, 101, 134, 160. We beg leave to rise and sit again on January 31st, 2023. With respect to the budget bill, House Bill 1, the following sections were explained on 1/31/23. Section 205, 206, 38, 78, 300, 308, 309, 310, 311, 313, 316, 321, 325, 327, 328, 329, 330, 331, 332, 390, and Section 4. The Committee of the Whole adopted a do-pass recommendation on House Bill number 1.
You have heard the motion. All those in favor say aye. All those opposed, no. The motion and the report have been adopted. Mr. Majority Floor Leader.
Mr. Speaker, I move the House resolve itself into Committee of the Whole.
All those in favor say aye. All those opposed, no. Motion carries. Chairman Olson.
All right, the Committee of the Whole will please come to order. First bill for our consideration is House Bill 128. The reading clerk will please read the bill.
House Bill 128, sponsored by Representative Clouston. Voyeurism within enclosed spaces, an act relating to crimes and offenses. Mr. Speaker, your Committee Number 1 Judiciary, to whom is referred House Bill 128, Voyeurism within enclosed spaces, respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Crago, Haroldson, Jennings, Nemec, Oakley, Provenza, Rodriguez, Williams, Washit. Representative Washit, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Washit?
Mr. Chairman, I move that when the Committee of the Whole rises to report, to do so with a recommendation of House Bill 128. That's the right number? Do pass. And I turn over explanation of the bill to the sponsor.
Representative Clouston.
Thank you, Mr. Chairman. Ladies and gentlemen of the House, this is a technical fix to our current voyeurism law. This was brought to us from a county attorney on the western part of the state, and I had it checked out by the county attorney in my hometown, and he too agrees with this change to the bill. What it is simply is that currently a voyeur has to be looking into a room. We had a situation on the western part of the state where the voyeur was actually in the room, like a big locker room or dressing room. So voting for this bill takes away that technicality where they would actually be charged if they were either looking into the room or they were in the room with the person who's expecting the privacy. So I ask for your support on this, and we'll get rid of this technicality on one of our laws. I'll stand for questions.
Oh, question being called. All those in favor of Chairman Washington's motion that when the committee of the whole rises to report that it do so with the recommendation that House Bill 128 do pass, signify by saying aye. Any opposed? Whoa. All right. House Bill 128 has passed the committee of the whole. The next bill for our consideration is House Bill 145. The reading clerk will please read the bill.
House Bill 145, sponsored by Representative Washit. Disclosure of sensitive information, law enforcement, an act relating to the administration of government. Mr. Speaker, your committee number 1 Judiciary, to whom is referred House Bill 145, disclosure of sensitive information, law enforcement, respectful report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Craigo, Nemec, Oakley, Provenza, Rodriguez-Williams, Washit. Noes, Representatives Haroldson, Jennings. Representative Washit, Chairman.
Heard the reading of the bill. What is your pleasure, Chairman Washit?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 145 do pass, and I will explain the bill if it pleases the chair.
Yeah, please proceed.
So what I bring you is an amendment really to existing statute, which will allow our division that maintains law enforcement sensitive information to share that information as necessary with selected members of the Department of Homeland Security. I can say that because they're named in the bill. Right now, under Wyoming law, we have this division authorized to release law enforcement sensitive information to particular agencies of our state government as needed. And they are listed in your bill on page 2. You'll see this list, several different agencies that receive information when it's needed to be shared. The division that maintains these records can only share that information if it's authorized by statute. So we have this relatively new state agency, Homeland Security, which was not included in this litany of agencies that are authorized by us through statute to receive law enforcement information occasionally. This agency, the Department of Homeland Security, the Office of Homeland Security, by its mission, from time to time, has to deal with threats of terrorism or man-made disasters, as well as natural disasters. So while it's fairly infrequent that this agency would need to receive law enforcement sensitive information, when those occasions arrive, it may be critically important that we have all the players at the table, that all of the stakeholders who need to receive that information can, by law, receive that information. And so those of us who have a lot of gray hair remember after the 9/11 attacks, one of the big complaints was that government failed to connect the dots. And what we're doing in this bill is we're providing a mechanism in law so that this division can share law enforcement sensitive information when they see appropriate with this department. This does not allow this new state agency to have a computer terminal linked in with the division or anything like that. It simply allows the division, at their judgment, to share information with this office. And with that, I'll stand for questions.
Questions on House Bill 145? Question being called. All those in favor of Chairman Washit's motion that when the committee of the whole rises to report that it do so with the recommendation that House Bill 145 do pass, signify by saying aye. Any opposed? House Bill 145 has passed the Committee of the Whole. The next bill for our consideration is House Bill 190. The reading clerk will read the bill.
House Bill 190, sponsored by Representative Harshman. Wyoming Value Added Energy and Industrial Plan, an act relating to the administration of government. Mr. Speaker, your committee number 9, Minerals, Business, and Economic Development, to whom is referred House Bill 190, Wyoming Value Added Energy and Industrial Plan, respectfully reports same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Burkhart, Conrad, Larson, Lawley, Western. Noes, Representatives Banks, Heiner, Knapp, Tarver. Representative Burkhart, Chairman. This bill was re-referred to Committee Number 2 Appropriations. Mr. Speaker, your Committee Number 2 Appropriations, to whom was referred House Bill 190, Wyoming Value Added Energy and Industrial Plan, respectfully reports same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Swanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Burkhart?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rise to report, it do so with the recommendation that House Bill number 190 do pass, and I further move the adoption of the Standing Committee amendment and turn the explanation of both over to the good bill sponsor.
Representative Harshman.
Thank you, Mr. Chairman. Members, I bring you today House Bill 190, Wyoming Value Added Energy and Industrial Plan. And really, we have currently appropriated and in this budget $382 million, 382 million, I believe is the number, to the executive branch to undertake energy and value-added type initiatives. And so what this bill does is really get us into the game, and it's something we did years ago, and it's been, and 10 years ago, 12 years ago when we did this, something similar. We produced I don't know if I can say the center in Campbell County that's hooked up to a coal-fired power plant that has a prize attached to it, and researchers all over the world. That came about from this similar legislation 10 years ago. Also, the core lab at our university, which is so important to unlocking minerals in our state. It's just been an incredible deal. So now it's our chance. We've got this one-time money we've appropriated. So this gets this branch of government involved. And so members, if you flip over to page 2, we usually don't put a lot of findings in bills, but this is about our opportunities in front of us. And then it appoints a task force of members of this body and 3 from the Senate. That's on page 3 and 4, be members of the Minerals Committee. And then talks about on pages 4, 5, and 6, what this task force will do. And then over to page 7 as well. It's got all these big ideas that are right in front of us right now in our state. And then finally on page 9, the governor then can appoint some task forces, include legislators, and he will staff those. So more legislators will be involved in this. And then I would just say the amendment on page 13 puts LSO staffing in charge of the legislative task force and the governor in charge of governor's task forces. And then, Mr. Chairman, the appropriation for the bill, if you look, really there's a $100,000 from general fund for this bill. And that is for the staffing of it from the LSO, for the LSO. And then the 3.2 million that you see is really, it's from this 382 million that is already appropriated. So that's, we use that to get some of these initiatives going. And finally, I'm trying to be quick because there's a lot of bills on general file and we want to set a new House world record today. How about 55 bills today? Okay, so we got 2 done. This could be number 3. So I just say that many of these things that you're going to be involved with won't actually bear fruit for a decade. And we're going to see that, the nuclear plant wasn't just started last year, right? All these things take time. And so, but if we can really get going and get our ideas, there's 62 type A idea machines in here, and we want to get everybody working on this. and I think was well supported by the executive branch. Some of the comment is that it added more rowers in the boat so we can all row in the same direction. And so with that, I'd stand for any questions. Appreciate your aye vote. And I guess I'd call for the question on the amendment first, if we can do that, or?
Okay. You have heard the question on the Standing Committee Amendment number 1. All those in favor signify by saying aye. Aye. Any opposed? Standing Committee Amendment number 1 to House Bill 190 has been adopted. We are back on the bill. Representative Hornock.
Thank you, Mr. Chairman. Question on the bill, just to clarify some things. So you talked about $382 million to the governor. So is that, we're developing a task force to talk about that fund. We talked earlier today about the amount of money in various parts of our budget that will go to the governor to be allowed to be spent for various things, $310 million and other stuff. Is that what we're talking here? So the $382 million has not necessarily already been appropriated. It may be if we pass that supplemental budget. Thanks.
Representative Chairman Harshman.
Yeah, thank you, Mr. Chairman, for that question. About half and half. Yeah, there's more in this budget to add to last year to get us to that number. Absolutely. And so, and again, just to get us all really in the same boat, rowing in the same direction, there's people in this body that have a lot of expertise in this area. And there are a few counties that are really primed as well to really take off with Wyoming on this. So that's what it's about, to get us all in the same room and working our ideas together in a collaborative fashion.
Representative Heiner.
Mr. Chairman, thank you. We used to have a saying in the business world, what can we do to make an elephant dance? It's pretty hard. The bigger the animal, the harder it is to get it to move quickly. And what this does is creates another layer of government, another task force. So I urge everyone to look at that, and I bring the question to the good bringer of those items listed on page 6 and 7 of the bill. What would not fall under the existing purview of Standing Committee number 9 that we already have stood up that is charged with these type of projects? And why can't we use that Standing Committee for this?
Representative Harshman.
Thank you, Mr. Chairman. Yeah, and I think the good committee, you actually don't know what you're going to be charged with yet. Management Council will give those charges at the end of the session. But I think the members of this will probably be some members, and particularly members who have expertise in these areas. But I think as all of us who have returned know, you know, when you get on your interim schedule and you serve on a couple committees, you know, it's different. And so what we're going to do is get some folks to really invest a lot of their life into this and go to work on it. So that's, so I don't see that as, I think the comment was growing more government, all that. I don't think it's about that. I think part of it is about the appropriations branch of government. And there's 62 of us in here. And I think it's important for us as elected representatives to be involved in this as well. And because we're the folks out there, we represent the 9,000 people we hear from. And so it's so important. Thank you, Mr. Chairman.
Representative Davis.
Mr. Chairman, being new here to this operation here, I just would like a little further explanation. We have $3.2 million that you're putting in there. Where did that $3.2 million originate from that then became unappropriated? Does that make sense?
Representative Harshman.
Thank you, Mr. Chairman. So the appropriation of 3.2 from unexpended, unobligated funds from our session laws from last time, that was appropriated to the governor's office. And if you look in the bill or on the fiscal note, it'll, on that second paragraph of the fiscal note, it'll tell you. So these are already monies we've appropriated. It's not going to affect your goldenrod at all. And probably won't even spend all that, but that gets us kind of moving and carves out a little bit for us to get going. So those are monies that are already appropriated in the budget bill last year.
Representative Davis.
Since, Mr. Chairman, since I don't have that
prior appropriation bill. Could you refresh my memory what they were originally appropriated for?
Chairman Harshman?
Mr. Chairman, and I don't have that bill right in front of me either, but it's basically for energy projects, economic development type projects through the governor's office, Agency 1.
Speaker Pro Tem Stith.
Mr. Chairman, I speak on in support of House Bill 190. I think this is part of having an economic strategy for the state. We've got a lot of temporary surplus money, and the question is, we want to use the government in a responsible way to do things where there may have potentially been a market failure. And these large projects, large infrastructure projects, are things that any one individual business, it's not in their interest to create a huge, say, a large-scale industrial park, for example. Any individual business isn't going to be able to put in a $40 million or a $60 million water line or do something that makes sense to do. What this bill does is it sets up the structure for us to study, does that make sense? So I think this is a small step forward, and it makes a lot of sense for us to think more strategically about our state so that we're not just digging and shipping things out of state, but rather taking those minerals, those rich minerals that we have, and adding value to them. So on and support.
Chairman Burkhart?
Thank you, Mr. Chairman. Just some things for the body to consider. Doing this is not unusual. We did this a while ago with Select Federal Natural Resource Management issue, where both the Minerals Committee and the Agriculture Committee were considering overlapping issues. So that committee was formed to do that, to take some of the workload on those overlapping committees instead of having both committees meet jointly and then look at those issues. They were authorized to bring forward bills if they wanted. While this doesn't do that, that's just an example of some of the things we've done in the past. So if you look at this, it gives the governor the opportunity to appoint a task force without a lot of specification. That task force could be one person, it could be 100 people. Then they come back to this body with a recommendation that this body then says, yeah, that sounds good, through the group set up here in this bill. And these are rhetorical questions. Please don't raise your hand, because we don't do that. But how many of you know and understand and want an oversight of what we might be doing with gold mining in Wyoming? There are gold mines going in, I can tell you that. How about the rare earths? Do you want to know what's going on? Do you want to have some oversight if a rare earth company comes and says, we'd like $50 million out of this account to match us? Do you want to have that oversight? And that's what this gives this body, is some oversight and some ability to provide our input when we're not in session. Because we're only here 37 days out of the year, and some of these issues are being worked continually. I can tell you right now, and I found out by accident, but there's a group that is visiting one of our national laboratories working on some things. I would like to know what they're doing and what kind of money they're talking about spending on what. That gives us the opportunity to have some oversight on this with a group that would include our Minerals Committee, include others, so that we know what's going on, where the money is going to. So when your neighbor asks you, hey, how come the state spent $15 million on a chicken cannery, you can explain it. If you like canned chicken, I guess. So, but it lets us have some oversight into that. And we have a lot of projects pending out there right now. Billions and billions of dollars coming into the state on major projects. You've heard of the hydrogen hub, but we don't hear much about it. And if there was something else, the budget mentioned addition of looking at lithium deposits and lithium mining earlier. This would give the legislature an opportunity to have a group who would at least be knowledgeable about these issues and be able to make recommendations, come back to this body and say, well, we looked at it and we didn't think that was really viable, and advise the governor not to spend the money. So that's what this does. I think it's worthwhile to consider these and to look at the main push on this. Was a few years ago, a group of legislators went to the nation to the north of us and looked at a facility they had there. We talked about the potential to build a similar facility where you had crude oil come in one end and the only thing that left there was a finished product. Vinyl windows, asphalt roofing shingles, and a whole bunch of stuff. That kind of dropped by accident. We dropped the ball on it. This would let us continue with that, to use our great resources for those kind of things. Question was asked here the other day about what the money for a coal refinery was going for. We can explain those things. So that's the reason for the bill. Give this body some oversight, give this body some input into a lot of this economic development without, each of us kind of doing our own thing, which causes a lot of confusion. If and we're all doing it. A number of us are in this room are working on the same project, but don't even know we're doing it. So it gives some coordination, it gives us a coordinated effort, because when you go to these companies and talk to them, and you have 4 different groups appear on 4 different days, they start to wonder, what are those people doing? Don't they even talk to each other? So we need credibility, and this gives it to us. So on and for the bill, and I'd ask you to support it.
Representative Hornock.
Thank you, Mr. Chairman. So my question would be, what happens if we don't pass this bill? We've got, we're potentially allocating a bunch of money for the governor to go out and take it to these industries to help facilitate giant projects. The task force seems fairly reasonable, but what happens otherwise? What happens if we don't pass this bill? Who has the oversight then? And what does happen in that point in time?
And just a caution on referring to the chief executive. That's Representative Wiley.
Mr. Chairman, thank you. My fellow representatives, hey, this is planting the seeds for economic development and diversification. What happens if we don't? I'll tell you what happens, nothing. And that's not going to be good the next decade. So if we ever want to bring our economy out of a one-trick pony and have some better base and broaden our stability within our economy, this is the tool to do that. On and forward. Thank you.
All right, question being called. All those in favor of Chairman Burkhart's motion that when the committee of the whole rises to report that it do so at the recommendation that House Bill 190 do pass, say aye. Any opposed? House Bill 190 has passed the committee of the whole. The next bill for our consideration is House Bill 126. The reading clerk will please read the bill.
House Bill 126, sponsored by Representative Crago. Trespass, removal of trespasser, an act relating to crimes and offenses. Mr. Speaker, your committee number 1, Judiciary, to whom is referred House Bill 126, trespass, removal of trespasser, respectfully report same back to the House with the recommendation that it do pass. Ayes. Representatives Crago, Haroldson, Jennings, Nemec, Oakley, Rodriguez, Williams, Washit. Noes. Representatives Chestick, Provenza. Representative Washit, Chairman.
For the reading of the bill, what is your pleasure, Chairman Washit?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with a recommendation that House Bill 126 do pass, and I turn over an explanation of the bill to the sponsor.
Representative Crago.
Thank you, Mr. Chairman. I bring to you House Bill 126 and ask for your favorable consideration. House Bill 126 is essentially a codification of common law, not only in Wyoming, but across the country. We've been able, the provisions set forth in this particular bill have been the case in Wyoming since we've been a state. And I had a constituent come to me and he teaches a lot of self-defense and church security back home and around the country, actually. And he said one of his main questions when he's putting on these classes is, where is it written that if we need to, we can remove somebody, for example, from the church or from our business? And his answer is, in Wyoming, it's not. And in other states, it is. And so this bill is really taking language from several other states. It's actually pretty foreign language from a lot of our sister states, several of them that are directly around us, and putting it into statute so that our folks back home can actually find the law, see what the law is, and they don't have to talk to one of those dirty lawyers to figure out what the law is. And so that's really the intent of the bill. It's a constituent idea. I think it's a good one, and I would stand for any questions regarding the specifics of the language within the bill.
Chairman Burkhart.
Thank you, Mr. Chairman. Just a question. In the bill, it talks about criminal trespass. Would this also carry over to trespassing to hunt or fish?
Representative Craigo.
Thank you, Mr. Chairman. It would not necessarily carry over to that because the way it's applied, it's in the criminal trespass statutes. And it's for the criminal trespass and the way the bill is written, for criminal trespass to apply, you have to be on notice and you have to have been given the chance to leave. And so it wouldn't, unless you were, it could apply in the hunting circumstance. If, for example, a landowner comes upon a hunter and says, hey, you're trespassing, I need you to get off my private property. And the guy looks at him and says, I'm not leaving. I don't care if I'm on your private property or not. Then it could. But otherwise, really, you're mixing apples and oranges in there because trespass to hunt is a different statute and it requires different types of proof separate from this.
Representative Chested.
Thank you, Mr. Chairman. On and against this bill. As the good bringer of the bill has pointed out, this rule is already embedded in common law, which is judge-made law. It's enforceable just as much as statutory law is. Changing it from common law to statutory law, I think, makes the law more rigid. I do trust the common sense of the judges as they hear cases and decide cases to apply the law in a common sense way. And putting it into a statute makes that more difficult, makes it harder to change if we need to change it. And therefore, I'm opposed to the bill.
Minority Floor Leader Yin.
Mr. Chairman, thank you. And maybe for the good bringer of the bill. So what happens if I am on somebody's property and I have a gun and the person believes that I'm criminally trespassing, so they try to drag me off of their land, and I think that my life is being threatened by them trying to force it, and I shoot them and they die, what happens in court?
Representative Craigo.
I think that's why we have juries, Mr. Chairman. But to be honest with you, again, for this bill to apply, you have to be, quote unquote, be a criminal trespasser, which means you have to have been put on notice that you were there illegally. I can't just stumble across you and start, grabbing you, punching you, kicking you, whatever. That's not how this works. You have to have the opportunity to leave first. And that's the whole point of the definitions within using the word criminal trespass within the particular bill language.
Representative Ward.
Thank you, Mr. Chairman. So there's a store, it has a big blue sign and sort of a yellow sunshine as its logo. Supposing this store said that I had to wear a mask to go into a store and I refused to wear a mask. And so they want to kick me out because I'm trespassing. Now are they allowed to use reasonable force against me because I won't wear a mask?
Representative Craigo.
Thank you, Mr. Chairman. So that's their private business property. And they have rights to set rules on whether or not you are trespassing and what that looks like. And so if you're there illegally and you fail to leave after you've been asked to leave, then yes, you can be escorted out of the building.
Representative Stivar.
Thank you, Mr. Chairman. Okay, the question I have, you're at a school board meeting and they tell you to leave. Can you be criminally trespassed from public property?
Representative Craigo.
Thank you, Mr. Chairman. The answer to that, of course, is yes. Even though it's public property, there's certain rights that still apply, whether it's so long as it's not your property.
Representative Stivar, you good? All right, Chairman Washit.
Just want to remind the body that there's still a reasonableness requirement built into this change. And so not any amount of physical force, but reasonable amounts of physical force. And as the good professor from over the hill mentioned to us, this is already the law of the land, only it exists in case law rather than in the green books where everybody looks to discover what the law is. And so by moving this from common law into the green books, our citizens and people across the state will be able to more readily know what the law is. We've had this discussion before. There are value in having laws in the green books where most of us would look to find out what the law is. So on and for the bill.
Minority Whip Provenza.
Thank you, Mr. Chairman. So as it stands, common law would allow for you to remove folks from your property under reason. So we don't necessarily need to put this in the green books. And part of the issue that we had in committee was that we didn't have a concrete case that was brought to us where someone said, I tried to remove somebody from my property and I was in trouble. So the law as it stands is working. And there's a possibility that if we bring this in, that maybe it can be used in defense cases that, or for a defense that necessarily shouldn't be applied. So I think that there's some issues with that. I mean, if we're not trying to solve a problem that has been brought to us, then I don't know exactly why we need to bring this legislation. Thank you, Mr. Chairman.
Representative Rodriguez Williams.
Thank you, Mr. Chairman. On in support of the bill. I think it's a good idea to codify it, put it in the green books, and on in support.
Representative Haroldson.
Thank you, Mr. Chairman. So on in support as well, and I want to just kind of give a scenario that how this was foundationally brought to us was an individual who is training security teams for places like churches or businesses and saying, you know what, these individuals who are being trained, they want to have a concrete, this is what the process is, and we can have that in codified law through this bill. And so I think it's vitally important that we understand that it turns into gray area. Yeah, we have case law, but we don't have actual concrete codified law that we can show them, hey, you know what, in these situations, this is the process that would be a legal process. And so by doing this, it's creating a framework of sorts where people can have an understanding of what they're capable of doing. And I'll just give an example. So for me as a pastor in our church, an individual comes in, maybe they've had just a little bit too much to drink, and we said, hey, you know, why don't you just call it a day? Why don't you move on out? And they say, oh no, I'm staying, I'm good. And I put an arm around them and I just walk them out of the building. This would put in codified law that is a reasonable process for me to help this individual out the door and explain that, why don't you sober up and come on back? And that would be that reasonable force. No, I don't deck the person in the foyer of the church because that's a non-reasonable force, but it gives me the opportunity to do that. So I think this is a great bill on and for.
Representative Haroldson, you really do not need the mic, ever.
The problem is YouTube does.
Representative Stivar.
Thank you, Mr. Chairman. I just want to re-clarify something. So how is this going to work if you're at a public meeting on public property, they can trespass you? How is that going to work into this bill?
Representative Grego.
Thank you, Mr. Chairman. In response to the former questioner, again, you have to be illegally or unlawfully there before you can be removed under this statute. And so there would, depending on the circumstances of the case, right? So they can't just ask you to leave a meeting if you're not doing anything wrong. If it's a public meeting, you're entitled to be there the same as everybody else. Now, if you create a breach of the peace situation, for example, you fail to follow the rules of the meeting, any of us can be removed for a meeting, a lawful meeting of any governmental entity, including this one, if we fail to follow the rules. And so I guess it would really depend on the situation, but the intent is, as long as you're there lawfully, then they can't ask you to leave. But if you get outside those bounds, then of course they could ask you to leave. And if you fail to leave, then this statute could come into play, or bill, excuse me.
Representative Alaman?
Mr. Chairman, I'm a little bit confused on the bill, as I'm sure many of our ranchers are. I think they will think that it's an illegal trespass if they're hunting or fishing on their place, and I'm afraid that they're going to take it like they can handle the problem. I like the bill, but I am a little concerned of how our ranchers may take the idea of the bill in the future. Thank you.
Question being called. All those in favor of Chairman Washit's motion that when the committee of the whole rises to report that it do so at the recommendation that House Bill 126 do pass, signify by saying aye. Those opposed, no. House Bill 126 has passed the committee of the whole. The next bill for our consideration is, Mr. Majority Floor Leader.
Thank you, Mr. Chairman. There's some, and check your site there. Let's see, make sure that it's updated. I'm just going to give you the next ones down here. Representative Stith is going to be coming in to deliver his bill next. Right after that is going to be 126, 129, 121, 206, 172, 160, 147, 119, 103, and then 185. Now, that might be exactly what you thought, but I just want to double check so there's no surprises. And I will tell you this, I'm not telling you all what to do, but the longer that we go, I have got a pile of bills that all mean a lot to every one of you folks in here. So I'm just letting you know, they've got to come through this pipe right here. So the longer we take, the fewer of those are going to make it. We got to have them through this committee by Monday. So
Wise wisdom from the Majority Floor Leader, folks. Next bill for our consideration is House Bill 126. The reading clerk will please read the bill.
That was 126. We're on 129.
My apologies, that was 126. The next bill for our consideration is House Bill 129. The reading clerk will please read the bill.
House Bill 129, sponsored by Representative Stith, Wyoming Private Employees Retirement Savings Plan, an act relating to labor and employment. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred House Bill 129, Wyoming Private Employees Retirement Savings Plans, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chadwick, Harshman, Olson, Wiley, Yin. Noes, Representatives Haroldson, Knapp, Ottman. Excused, Representative Newsom. Representative Olson, Chairman.
Chairman Olson.
I move that when the committee of the whole rises to report that it do so with the recommendation that House Bill 126 do pass, and I further move the adoption. Is it 129? My goodness. I'm going to get this right. I move that when the committee of the whole rises to report that it do so with the recommendation that House Bill 129 do pass, and I further move the adoption of the standing committee amendment. I'll turn over the explanation of both the amendment and the bill to the sponsor, the representative from the land where the water is sweet.
Representative Stith.
Mr. Chairman, thank you. I would call for a quick question on the standing committee amendment. What it does is it increases the number of legislators on the task force, makes them voting members so that any proposed legislation coming out of it would be voted on by the members of the legislature, and it also makes the appropriation for this task force in accordance at $75,000 in accordance with the recommendation from the director who is in charge of our retirement system. So with that, call for.
Question being called on standing committee amendment number 1 to House Bill 129. All those in favor say aye. Any opposed? The standing committee amendment has been adopted, and we are back on the bill. Representative Stith.
Mr. Chairman, I
Please
present to
proceed.
you House Bill
Speaker Pro Tem
129. Ask for your favorable consideration. What this bill does is it creates a task force that would, the end product of which would be a feasibility study to say, does it make sense here in Wyoming to have our employees, if they're not part of a pension plan, if they're not a government employee, but they're a private employee, and they don't have a 401k, does it make sense when they first get their job to have them automatically enrolled in a 401k plan that the state essentially would administer? And if the employee wants to opt out, the employee would be able to opt out. That's really what this task force would be looking at. And the purpose of it is this: over half of households with people aged 65 to 74 have no retirement savings at all. And so this bill, and it's a principle sort of behavioral psychology, that if the default is to opt in, more people will participate. You get some young people who would, working as a fry cook, they would be automatically enrolled into a 401k plan. And the purpose is so that when they're older, they have the freedom to determine their own destiny. They've got some savings of their own. And for the state, it could make a lot of financial sense, because we right now are spending a lot of money on nursing homes. Most people can't afford to be in a nursing home. And right now the state's picking up the tab for that along with the federal government. So this is both fiscally good for the state, but it also promotes the value of self-determination and self-reliance by our individual private employees. So I ask for your aye vote.
Representative Haroldson?
Thank you, Mr. Chairman. So a couple things, that this came before the committee I stood on, and a couple things that we need to talk about. It's the amendment we just passed through has another 25,000 in there to bring it up to 75,000 for the study, just so you're aware. The second thing that you need to understand is the fact that in 2018, the same study was conducted, and at that point, I would assume was found not feasible. We're not sure because we haven't actually heard if it was feasible or not. But ultimately, is it the government's job to offer a retirement plan for private businesses? Obviously, it's going to, I mean, at the end of the day, this is a form of a socialized retirement. And do we want people to have a retirement? Absolutely. Should people have a IRA or a 401k? Absolutely. But is it the government's job to make that reality? And I understand the conversation or the comment on the backside that if we don't do this, we've got a problem with high cost in our nursing homes and stuff of that nature. So I believe that this is a conversation that, I mean, we've already had a feasibility study in 18. I doubt that feasibility study has changed that much in the last 5 years. The other thing that you have to understand is this really a 401k or retirement plan issue, or is this something that we need to start changing how we train in the K-12 and college level to where we actually start giving the conversation of what this looks like? I don't know. I just think at this point, we're going to put $75,000 into a feasibility study that we got 5 years ago and didn't act upon at that point. And really the question is this our job in the first place?
Mr. Chairman.
Speaker Pro Tem Stith?
Mr. Chairman, in response to the question, there was a study done in 2000 that produced a report in 2018. It was not a feasibility study. That report said, well, one of the things you could consider would be some form of automatic enrollment. And that at the end of that report, it said, if you wanted to do the feasibility study, and the feasibility study really is going to look at the numbers to say, hey, you know, we're a small state, right? So there might be diseconomies of scale. This ultimately might have heavy administrative costs. It wouldn't be nearly as efficient, say, as our public employee retirement system that we have now. Does it make sense for us to do this? But right now, we don't know what the price tag from administratively would be. And the question is it worth it for the state to look into this so that we avoid millions and tens of millions of liabilities in the future? Because right now, 65% of the people who go into the nursing home aren't paying for it. The taxpayers are paying for it. If we can get that percentage down just a little bit by having people have their own savings retirement, the $75,000 will be a very cheap investment. So,
Representative Wiley?
Thank you, Mr. Chairman. Yeah, I testified to this in committee, and you know, when I graduated high school or college, I wasn't taken into a room and said, here, have a half an hour with a financial advisor, right? So I think at the end of this, we still have the option of opting out. So I don't believe this is fully overreach or socializing
a retirement option, because you could say, hey, I don't want to do this. I don't need to do this. I can take care of myself in my later years. We don't need this as an option. And then I want to touch back on the task force that was put in place in 2018, and this committee was actually a recommendation from that task force to figure out how we can do this, or if it's feasible. So I mean, if we could get to a position to where we're able to save 52 million, 100 million, and then not have to have that go through Medicaid plan or something, and still take care of folks, why shouldn't we at least look at it? It would be a good fiscal option for the state. It's being paid for anyway. I would ask everybody to really think about that. Thanks.
Representative Hornock?
Thank you, Mr. Chairman. So I see this task force as a bit unnecessary because I think this goes down a road that I don't know that we can go down. Frankly, if any of us in this room have even one employee, we kind of have a conflict in voting for something like this, because this means that I don't have to provide any retirement savings to any employees. I don't need to even go there. So I think by doing something like this, we're one of the incentives that employees offer over other employees when you're battling for that employee is, well, does one company offer retirement? Does another company not? So if you have even one employee, this takes that burden completely away from you. You can throw your hands up in the air. You can let the state take care of it. So I don't really see the need to even go down this road with a task force. So I would recommend a no vote. Thanks.
Representative Baer?
Thank you, Mr. Chairman. I also don't see the need for a task force because we've got decades of study where the federal government has had a Social Security system. And that system, as we all know, is failing. Government does not belong in the business of retirement. We are not the best option for ensuring that people are better off in the later years of their life. Best option is for people to make those decisions themselves. We often say, if we could just save some dollars down the road. Well, we can look at the federal government, and they haven't saved, they've managed to spend. They've taken what opportunity there was for people who've had money taken out of their checks every couple of weeks, and they've made it a system that's nearly insolvent. And that's why today we all would prefer to have 401ks instead of having our money in Social Security. We know that there's many of our constituents that are on Social Security that are not getting by. They're having to work. That's why we have this problem with the later in life healthcare too. Government is not the right solution for this. There are solutions, but this is not one of them, and I think it's a waste of money to spend on a task force. Thank you.
Representative Heiner?
Chairman, thank you. This session, we've been dealing with a lot of pensions throughout the state. We've backstopped with millions and millions of dollars the various pensions that we have. So a question for the good bringer, do you envision any public money being expended for these private employees in the future? And if not, what's the reason for the state to be involved in this pension?
Speaker Pro Tem Stith.
Mr. Chairman, thank you very much for the questions. To address those, with respect to the small employers, it is true that only 19% of businesses with 10 or fewer employees are offering retirement plans. So and what this bill potentially would do is develop a plan to get that number up much higher, because having only 19% of our businesses participating is not desirable. With respect to the question of public money being involved, because that's where the rubber meets the road, right? So it's not contemplated that any public money would be flowing into these retirement accounts. However, it would likely be a proposal that the government would be paying for some of bearing the administrative costs of administering the plan. What is that? Is that 0.1% of the fund amount, it would likely be something. And the real question for the feasibility study is it worth it? If it's going to cost the government $250,000 a year to administer it, what's the payoff for the state in 20, 30 years when people are populating the nursing homes? We are on track to be spending between $180, $200 million a biennium on nursing home care by 2030 is an estimate. Again, that's an approximate estimate, but that's a big number. We are spending a lot of money on nursing home care. If we can get that number down by spending a little bit to administer the management of the private employees' money, that could be the return on investment for that would be very significant in favor of the state. With that, thank you. I ask for your aye vote.
Representative Wiley.
Thank you, Mr. Chairman. Yeah, I just want to remind everybody, unless I'm mistaken and I read this wrong, this isn't modeled after our Social Security model or pensions. All this will do is be a retirement option, much similar to the way the state retirement is. So you will have to pay your own money into it to be able to withdraw it later. That's all it is. And to be honest with you, the money within this is probably more protected than a hedge. And that's the difference between this and a private option. That's all. It's not Social Security, and it's not a pension program. Thank you.
Majority Whip Western.
Thank you, Mr. Chairman. I certainly appreciate the bringer of this and the problems we're trying to solve for. A lot of Americans don't save enough. That's bad. That needs to be improved. I think that much is indisputable, and I agree with certainly the costs that we will be incurring elsewhere down the value chain, nursing homes, et cetera. But I think if the idea is to get them to save more, why would we not just go to a lot of the private employers right now and say, hey, you need to do this, but already go with the privately provided retirement plans that they have. Obviously, we can't name them by name at the mic, but some of these ones that have these types of offerings. And I guess the follow-up would be, can they do a better job than if we did this internally at a state managed program? I mean, if this is about returning, generating returns for these retirees, can we do a better job? Can we generate higher returns after fees, net of fees, to these retirees and these folks? Because the reality is a lot of those upper income folks, they've got a pretty good IRA, 401k, et cetera, all those types of options on the table. It's those kind of blue collar and lower end or folks who are working those minimum wage jobs. If those are the folks we're trying to get them to save, I think one of the questions that needs to be answered is, can a state managed program do a better job and generate better, consistent year over year returns for these retirees? Because if we're not, and if we're not even close, we might as well just require these large private employers in our state to just say, hey, you just have to do this. It's just with a private manager. Thank you, Mr. Chairman.
Question being called. All those in favor of Chairman Olson's motion that when the committee of the whole rises to report that it do so with the recommendation that House Bill 129 do pass, signify by saying aye. Aye. Those opposed, no. No. House Bill 129 has passed the committee of the whole. Division being called. All those in favor of House Bill 129, please stand. All those opposed? More than 24. House Bill 129 having failed a standing division vote, a roll call vote is required. Chief Clerk, please call the roll.
Allemand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Burkhart? Byron? Chadwick? Chestick? Klauston? Conrad? Crago? Davis? Davis? Eklund? Haroldson? Harshman? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrop? Oakley? Obermuller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez Williams? Sherwood? Singh? Slagle? Smith? Stith? Storer? Strock? Stivar? Tarver? Trujillo? Walters? Ward? Washut? Western? Winter? Wiley? Yin? Zwanitzer Dan? Zwanitzer Dave? Speaker Summers? Burkhart?
Excused.
Storer? Allemand? Sorry. Can you repeat? Can you repeat your vote?
Allemand, repeat your vote.
Are there any changes? Closing vote. Vote closed. 24 aye, 36 no, 2 excused.
Pursuant to House Rule 6-6B, House Bill 129 has failed a roll call vote and is indefinitely postponed. The next bill for our consideration is House Bill 121. The reading clerk will read the bill.
House Bill 121, sponsored by Representative Lawley. Property Tax Deferral Program Amendments, an act relating to property taxes. Mr. Speaker, your Committee Number 3 Revenue, to whom was referred House Bill 121, Property Tax Deferral Program Amendments, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrop, Oakley, Storer, Strock, Zwanitzer. Representative Harshman, Chairman. This bill was re-referred to Committee Number 2 Appropriations. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred House Bill 121, Property Tax Deferral Program Amendments, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Harshman?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with a recommendation that House Bill 121 do pass, and I'd also move do pass on the Standing Committee amendment. Mr. Chairman, turn the explanation of this nice little bill over to the good representative from the heart of the beautiful Bighorn Basin.
Thank you. Representative Lawley.
Thank you, Mr. Chairman. I'd like to first go into a brief explanation of the bill, and then we'll talk about the amendment, and maybe it'll make a little more sense. So this bill is a result of concerns brought to me by constituents. It's probably a concern every one of you has heard related to property tax burdens on different people. And as I looked at it into the what I call sticky wicket of the property taxation and the different possibilities, I decided I would focus on relief. And so this is really a relief bill. What I'm doing in House Bill 121 is I'm seeking to amend a current statute that provides for property tax deferment. And you see that cited in the bill. And the statute has been on the books for many years, but rarely used. And as it stands right now, only one county actually uses this property tax relief, and actually under the statute is qualified to use it. So what we have is a situation where, and that one county is Teton County. And so what we have is that if your constituents don't live and have their primary residence in Teton County, they cannot access this relief. It's just that simple. Now, I hope you're asking why. Why can't they? I have a question over here. Why can't they access it? They can't access it because by terms of the original statute, they haven't met the requirements. And so you see in the repealer, in the statute, in my bill, a reference to the Section G of the statute that says the deferral option shall not be available to any county which has not adopted rules as required by subparagraph A of this paragraph, or which has received disapproval of the county program by the department. So objectively, according to the statute, the other counties just simply didn't adopt the rules. And what I want to suggest to you is that, well, this is a great program that the legislature adopted. I don't think that they envision some, maybe the practical problems, particularly for more rural counties, but we can see that really only one county has adopted rules. The other counties didn't, so they simply don't qualify to use the program. So what I've done is to try to address that issue because it really creates, as you can see, a very inequitable situation. There's relief on the books that the legislature's decided is an important avenue to offer relief through a deferment program, but it's not accessible at this point to 22 of the counties. So what the bill proposes to do is lift this program from the counties and put it up into the Department of Revenue. And it takes away what I think are some of the reasons that counties haven't stood up the program, basically. And one of them is the burden of the administration itself, and the other one is the financial burden of the deferment. So by pulling it up in the Department of Revenue, we're going to address some of those issues, and I'll get back to that in a moment, but I want to talk about the original statute had 4 pathways, if you will, independent pathways to qualify for the deferment. In my amendment, I've added a new pathway. All the others are exactly as they had appeared in the original statute, but I added another pathway for disabled veterans who have compensatory disabilities as determined by the Veterans Administration. So that's a new pathway, and that's what the amendment's about. So we have, I think the Chairman of Revenue did move the amendment, so we're ready for that.
Question on the Standing Committee Amendment number 1 to House Bill 121. All those in favor signify by saying aye. Aye. Any opposed, no. Standing Committee Amendment number 1 has been adopted, and we're back on the bill. Representative Lawley.
As I said before, I think there are really 2 primary reasons why that really 22 counties do not even access this program, or really haven't given their citizens access to this deferral program. And that's first the burden of administration and the burden then of the tax deferment itself, the financial burden. But there's a third one that we haven't talked about yet, and that is what I call the stigma of asking for the relief in the first place. And one of the things that I believe can happen by pulling it out of the counties and putting it in the Department of Revenue is we don't necessarily completely eliminate that stigma, but we make it better, because the truth is, people in trouble would rather ask someone in Cheyenne they will never meet for this kind of relief than they would ever want to ask anyone they'll see in the grocery store, meet at church, or see at the ball game. And so this kind of helps address the issue of the potential stigma to ask for the relief when it is needed. So the other thing that I think happens when we put it in the Department of Revenue is the promulgation of uniform rules across the state for the program. The department would then promulgate rules about how to handle it, how to receive applications, how they will manage the applications, because the amendment, this bill actually asked for $200,000 in appropriation for the Department of Revenue. Once they've identified and they have granted the relief, the deferment, they will reimburse the counties for that. So again, the counties won't bear the burden. The state will then, in exchange, have a tax lien on the property that will be fulfilled in a number of ways, and we can talk about that. If you have questions about that, it refers to it directly into the statute. But I want to just for a minute describe, for those that might not know or those that might be listening in, what is a tax deferment and how is it different than a refund, but particularly what is a tax deferment? Most simply put, a tax deferment is an agreement to delay the collection of all or part of a tax in exchange for a lien. And that lien secures the ultimate payment of the tax. So the tax is not forgiven. Its payment is simply delayed through a deferment. There's no loss of tax revenue, and the tax lien has a priority position by law above others. So the statute specifically has some sidebars on it that I think it'd be important for you to know about that were already in the current program. I didn't add these. Again, it's a great program in so many ways. But one of them is you can only defer up to half of your taxes in any given year, your property taxes on your principal residence only. And you can apply for additional deferments in future years. But once you reach deferments up to half the value, fair market value of the house or the principal residence, you can no longer receive any more deferments. So there are some protections on that side of how we protect the interests in terms of the lien and the amount of the deferment. This bill is supported by the Wyoming Taxpayer Association, the Wyoming Association of County Commissioners.
Whoa,
Sorry, I can't say those. Sorry. The association that deals with taxpayers, the association that deals with our counties, and can I say it this way, the association that deals with people my age.
All right.
Smooth.
Smooth.
I stand for any questions.
Questions? Representative Jennings.
Thank you, Mr. Chairman. So my first question to the bringer would be, how many people used this in the county that did accept those rules and put it in place? And then I would like to point a couple of things out to the body. This is not, as the good bringer brought, it's not reform and it's not rebate, it's referral or deferral, with the state becoming first in primacy. So I would like to ask the bringer, on page 3, starting with line 18, was there any testimony, and what was that testimony like that talked about the department shall constitute a perpetual tax lien in favor of the state against the property with a priority over any other lien? I'd like to hear the discussion in committee that was over that part, but I'd also like to know how many people accepted this in the one county that did accept these rules, and like to know why it wasn't perhaps used very much there.
Representative Lawley.
Yeah. I really don't have the numbers on what Teton County did. I know they have used it, and my understanding is they've actually used it more in the recent years than they had previously. So, but I don't really have the numbers on that. Concerning page 3, line 17, about the tax lien, first of all, by law, the tax lien got superior position. But we're concerning the department, if that's what you're wondering, is what their position was on that. Again, I'm not sure I understand your question. Maybe that would be helpful. You could restate your question.
Just a friendly reminder to go through the chairman. Make sure you go through the chairman. Representative Jennings.
Just wanted, Mr. Chairman, to know what the discussion was about, because this is a deferral, and it is putting the state, and that's correct, that they would already be if you were in default of your taxes. But here we're kind of inviting people to defer, which will put them in default. And along those lines, if you can defer only 1/2, but many of the taxes in the last couple of years have gone up 30% or more. So I was just kind of curious what the debate was like about that issue, both those issues.
Representative Lawley?
Thank you, Mr. Chairman. Well, there was really no debate on that issue because I think there was an understanding that it was a deferral program, and a deferment is an agreement to delay the collection of the tax, and it does not stand legally in the same position as non-payment. It's a very much a different track that you're on. There was some discussion by the Department of Revenue concerning they may have to pull in some, in terms of IT and things, to manage this program in terms of making sure the liens are filed and managing those liens, but there was really no discussion about that.
Speaker Pro Tem Stith?
Mr. Chairman, and I guess as I think it may clarify it and also ask the question of the sponsor. Right now, if you don't pay your property taxes, then there's a tax sale and tax certificates are sold. What this provides is that if you're allowed to pay half your taxes and then half becomes a lien, eventually you have to pay your property tax. This doesn't let people not pay their property taxes. It allows them to defer them until later upon sale of the home. So, and then if the person passes away, then whoever gets the house then has to deal with that. Either they sell the house, or just as with any other tax lien, the county treasurer would sell it at a tax sale.
Question being called oh, I'm sorry, Representative Ottman.
Thank you, Mr. Chairman. Just a question to the bringer. So as we talk about this, we all know that taxes have gone up, especially property taxes in certain areas more than others. But what I'm wondering is that, okay, with a deferment, if taxes continue to go up like that, property values continue to go up, and the state then would be the first primacy lien holders, what happens to those properties during that point of taking that and the share of sales and all that? And I asked that because in the 80s, I had the experience of that when the banking system called in loans, loan origination had gone from being the primacy into secondary, and loan servicing had gone into being the primary. They were not set up with rules, procedures, or experience in handling real estate properties. Those properties were trashed. The people that lost their homes demolished them, a lot of them. The other thing is pipes broke. There was properties left all over the county that were empty and fell apart, and it was a mess. So I was just wondering, how is that going to be handled?
Where's the chairman's wanted, sir?
Thank you, Mr. Chairman. So in the worst case scenario, let me tell you what happens now. If you don't pay your taxes, it goes to a property tax sale. They have 4 to 6 years to redeem it, and you're paying 15%. The great thing about this program, if you're the homeowner and you're not the person who goes to property tax sale like I am, is you can get half of it deferred and you have a much lower interest rate. So actually it benefits you if you can't actually pay your taxes and need that deferment. You're not being charged that same 3% immediate NIC plus a 15% interest. Long-term, you're getting a much better rate by the state, and you're probably more likely to be able to pay back your property taxes quicker and sooner and not have everybody in town know about it. And again, the bringer of this bill has it specified where there's a lot more protections on it. Main house under 40 acres, I believe.
Yes.
And so it's a little tighter for just those people in this category who we know or mostly are fixed income people and would have difficulty paying as inflation goes up. So it's narrowly tailored, better interest rates for those people to get their taxes paid back faster. But otherwise, the state has your property tax lien instead of the county and some private citizen like me who's more than happy in 4 years to try to get your property. I think the state's probably the better person at a better interest rate that you, if you can't pay your taxes, you can work with.
Representative Locke?
Thank you, Mr. Chairman. And just a question to the bringer of the bill. And this is just my assessment, but is it accurate to characterize this as not specifically brought into kind of the all of the property tax relief bills, some of these things where they're talking about a give back. This is more of you're fixing an existing tool that has been out there to allow property owners to use this tool in an ongoing basis. Did I characterize that accurately?
Mr. Chairman?
Representative Lawley.
Yes and no. It is part of tax relief. It's just another way in a basket of options. And quite frankly, this particular relief has less to do with the current issues in property tax valuations. It helps that, but it actually envisions a number of circumstances individual taxpayers can find themselves in where they need some kind of relief, sometimes even temporary. They may pay off their own tax lien, for example, but it gives another option, and that's why the fact that it's simply not even available to your constituents, I think should be of concern to you. So it is relief, but it's a different kind of relief. But I want to go back to the issue that the previous good representative raised, and I think there's a little confusions about two different ways that we work through tax situations where taxes are unpaid. That's why I carefully went through a definition for you of the term deferment and what it legally means. When you have received a deferment, you are not on the pathway for non-payment. You have, by agreement, been given by, in this case, the Department of Revenue, the right to not pay a certain amount or to defer, to not really not pay, but to delay the collection of the tax. It doesn't relate to the assessment of the tax at all. It's only about the collection. I think that's where some of the issues about experiences you may have had about sale of property where there was failure to pay. We're not on that path once you get a deferment. You're on a completely different path, and that ultimately the collection of the tax comes under the provisions of the bill that tell you exactly when they can be triggered. One is the Department of Revenue can determine, based on factors of what's happening with the property, they can trigger the collection of the lien and force the sale of the property or work with the property owner to collect that. But most commonly, how this deferment will be satisfied is through the exchange of the property by either sale or death, even a death on deed. Any sort of transaction for that property to change ownership cannot be recorded without those liens being satisfied. So that's how it would actually work in terms of how the satisfaction of those deferments comes.
Representative Grego.
Thank you, Mr. Chairman. I just wanted to point out, because there was a lot of talk about liens, and just so everybody knows, it's in Title 39-13-108D, and all these liens we're talking about already exist. We're not creating the new lien process within this statute, and it says, I'll read it to you, taxes upon real property are a perpetual lien thereon. And so just a little bit of background, once the assessment comes out every April, that's a lien. It becomes automatic. It doesn't have to be filed. It doesn't have to go to the county clerk's office. It just happens by operation of law. So we're not creating, and this is important information because as we get into a lot of these tax discussions over the next couple of weeks, just keep that in mind. Liens already exist. All of our properties in this state are already subject to those.
Representative Majority Floor Leader Nyman.
Thank you, Mr. Chairman. Also a question for the good bringer. What would the current rate be? What would we be paying, and what is your rate that you would be proposing in this legislation?
Representative Lawley.
Thank you, Mr. Chairman. Thank you for that question. Majority Floor Leader Nyman. Thank you for that question. The statute already has a provision. I didn't change the provision for the interest rate, but if you want to know what the number would be as we stand here today, how it would be calculated, is about 3.53%. It probably is projected to go up in 2024 up to about 4%. So again, it's a substantial difference from those who just decide not to pay and then where they have a substantial interest rate. But there is a modest interest rate that accrues on the deferred tax.
Gentle nudge not to use names of representatives from the mic. Representative Hornock.
Thank you, Mr. Chairman. So currently, every county has what is allowed, what's called tax sales. So you can kind of buy somebody's lien and pay their property tax, and then, there's a system where you can actually, after 5 years or so, acquire that property and things like that. So how does this change that system that we currently have in place in counties? Because it seems like it now turns over to the state. So just curious how this tax sale system that we already have in place will change. Thank you.
Representative Lawley?
Thank you, Mr. Chairman. Again, there's a little bit of confusion here still about the pathway of non-payment, which is, I believe, what the good representative just referred to, is if you do not pay your property taxes, it sets you on a path. That non-payment triggers certain things to happen, and over a period of time and with notice, and with a great accruing interest rate, that property comes up for sale eventually to pay the unpaid taxes. A deferment, again, is an agreement to defer collection. And in exchange for that agreement, for the delay and deferment of that collection, the agreement to defer the collection, there's a tax lien to secure the ultimate payment of the taxes. So when it's deferred, it never enters the category of unpaid because you have in place a deferment, an agreement. So I hope that helps. They're just two separate systems. They put you on a different pathway. In fact, in many ways, you're making the point of the value of a deferment. In so many ways, you've made the case for it. But what I would like to say to you, if you vote no on this bill, you're saying, in effect, that the citizens of your county it's okay that they don't have access to that. That's what you're saying. Because the relief exists. It's a very good, well-structured program. I honestly do not believe that the legislature that created that program ever intended this to be the problem it ended up being for many counties. They just didn't. So it's not functioning. And so we're simply trying to pull it up into Department of Revenue so it can function in an equitable way. And every citizen of the state that's a taxpayer has an option to seek this kind of relief. That's all this bill does, and then adds this additional pathway for disabled vets.
Question being called. All those in favor of Chairman Harshman's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 121 do pass, signify by saying aye. Aye. Any opposed, no. House Bill 121 has passed the committee of the whole. The next bill for our consideration is House Bill 206. The reading clerk will please read the bill.
House Bill 206, sponsored by Representative Yin, State Employee Child Care, an act relating to the administration of government. Mr. Speaker, the Committee Number 10, Labor, Health, and Social Services, to whom is referred House Bill 206, State Employee Child Care, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Chadwick, Clouston, O'Hearn, Trujillo, Yin, Swanitzer. Noes, Representatives Hornock, Penn, Ward. Representative Zwanitzer, Chairman.
You've heard the reading of the bill. Chairman Zwanitzer, what is your pleasure?
I have heard it, Mr. Chairman, and I move in the Committee of the Whole rise to report it do so with a recommendation that House Bill 206 do pass. I would further move the Standing Committee amendment and turn them both over to the good representative from Teton County.
Minority Floor Leader Yin.
Thank you, Mr. Chairman. So members, I would like to first dispense with the Standing Committee amendment, and then I'll go through the bill. So the policy decision decided by the Standing Committee amendment is whether to charge for childcare if we create this child care center in the Capitol, or to provide it free as a benefit. So the Standing Committee, I brought to them an amendment to decide that policy decision, and the committee chose to decide to charge market rate for childcare. And so that's all the Standing Committee amendment does, and I ask for your favorable consideration.
Question being called on Standing Committee Amendment Number 1 to House Bill 206. All those in favor say aye. Any opposed, no. And Standing Committee Amendment Number 1 has been adopted, and we are back on the bill. Minority Floor Leader Yin.
Thank you, Mr. Chairman. So members, I bring you House Bill 206, State Employee Child Care. So the essence and intent of this bill is to provide a child care benefit to state employees. We'll go through the bill a little bit, but to bring you the reason that I'm bringing the bill in the first place, I was thinking about how we talk about employee pay for state employees, and how we talk about the number of vacancies. So the good appropriators told us we had 1,400 vacancies across our organization. And so I was trying to figure out, how can we make ourselves more competitive? And I looked towards private industry, and I wanted to know, what does private industry do? And one of the things that stuck out to me is childcare. So in the Capitol, we have quite a few agencies that keep all of their employees here. And so I thought this is the thing that could make the most difference, even though it can't cover everyone in the state. So what it does is require A&I to provide childcare. However, what happens, and you can see because there's no fiscal note on this, what they'll come to us at the end of the bill, if you look on page 4 and 5, in section 3, it's the intent of the legislature that A&I will submit a budget request for the fiscal biennium, which is next year, on the establishment and operation of child care facility. And so it includes the cost for the employees, as well as provider costs if we decide to contract it out instead of doing it in-house, and building improvements if those are necessary. So in essence, and with the committee of the whole amendment that I will move after the explanation of the bill, it creates a plan for next year to decide, does the cost of doing this make sense for the benefit that we could receive for state employees? And that's essentially the goal of the bill in a nutshell. So it's to put a child care facility in the Capitol complex as a benefit to all state employees. So that means not just the ones in Cheyenne, but for state employees that have to travel to Cheyenne, and they are not sure what they can do for childcare. It provides a consistent and convenient benefit to allow them to have childcare in the Capitol complex itself. And I'll talk about some of the reasons why even just the benefit, even though it costs money, why it makes sense. And some of that is because if you are a working parent, you have 2 working parents in a household, you need a childcare facility. You've had one for a while, you were able to find space, and then they tell you, oh, you have 30 days, you got to find another place. So now you have a whole month where you're stressing out, trying to find childcare. In Teton County, it's a huge problem. In the capital city, I know it's also a problem. I've talked to a couple of state employees, and trying to find that creates a huge stress that makes you actually less productive as a state employee. And so you have productivity benefits, you have benefits for those traveling, and it creates something that makes us more competitive on the state level. And so with that explanation, before going to questions, I would like to move the Committee of the Whole Amendment number 1. So I'll move Committee of the Whole Amendment number 1 to House Bill 206, Mr. Chairman.
Okay, discussion on the amendment.
So, Mr. Chairman?
Oh, please.
Mr. Chairman, thank you. So it makes it subject to legislative appropriation. So you see on page 2, line 11, right now it says the department shall facilitate. What I didn't want to do is force the department in statute to run a child care facility if we didn't end up thinking that it was worthwhile once the budget comes in. So if the budget comes in and the request seems way too high for the benefit that it provides, all we do is we just make sure that's not in the budget, and then they don't have to run a child care facility. So essentially what we'll come up with is decide next year in the budget whether it makes sense as having this as a benefit for state employees. So I'll ask for your favorable consideration on Committee of the Whole Amendment number 1.
Discussion on the amendment. Question on the amendment. All those in favor of Committee of the Whole Amendment number 1 to House Bill 206 signify by saying aye. Aye. Any opposed? That amendment has been adopted, and we're back on the bill. Discussion on the bill. Representative Ward.
Thank you, Mr. Chairman. I am on and against this bill. I was on the committee that discussed this bill, and even with the amendment, this will increase costs and grow government. The reason that childcare is not available is because of crushing regulations, not because it's not available to state workers. On and against.
Representative Larson Lloyd.
Thank you, Mr. Chairman. As
As I listen to and read the bill, there's a couple of things that stick out to me, and that's just the overwhelming favoritism towards the state employees here in the Capitol, when we have a huge number of employees around the state in facilities that childcare is equally as challenging, whether you're at the state hospital, life resource center, any of the correction facility towns. And we seem to be sending the message that I don't think we want to send, that says, if you are a state employee in the capital city, you can have this benefit, but if you live elsewhere, you're just going to have to go without. And I don't see how that's addressed at all in the bill, and I really believe that that's sending the wrong message. But if the good, I know that the intent of this bill is as kind and as charitable as can be. Would the state then, would it be, another question, would it then be a state-run, or are we creating a new agency for this to be? So are we creating a new agency here? Or would this come under the jurisdiction of ANI? And these employees, these childcare employees now are also employees of the state. And that may be in there. And then it is. And so then the funding is subject to biennium to biennium. How many are the conditions of do you anticipate the conditions of the facility being open 7 days a week? I mean, or is that something that A&I would have to work through? I'm just wondering, as you've contemplated this, how you saw it. Are you seeing it open because we have people working? If snowplow drivers have to go out at night, are they going to have access then to childcare if that's a requirement? So some of those questions, if you'd be kind enough, I'd appreciate it, having a discussion on.
Representative Yin.
Thank you, Mr. Chairman. So for the good Vice Chairman of Appropriations, the question on whether this affects all in-state employees, it does not affect state employees who work outside of the Capitol, essentially. But it does still allow any state employee who comes to the Capitol to be able to use it. So it technically does allow for all state employees, but if you are living in Riverton and you are not coming to the Capitol, then you probably won't be able to use it. But it still provides that convenience. If you have to come to the Capitol for whatever reason, maybe it's to answer to the legislature for something, they'll be able to bring either their kid or grandkid and know that there's a facility available for that. And I think it's unfortunate that I didn't bring a bill to cover everyone, but I think the ask for that is much larger, and I worry that that's not something that would be as feasible. So I wanted to do the most good and provide the most benefit, and not to be charitable, but to be competitive in the private market. So that's the biggest thing. And then with regards of whether they'd be state employees or not, so if you look on page 4, lines 14 through 16, so it would fall under A&I, under the General Services Division. But they can contract that out, so the child care provider doesn't necessarily have to be state employees. It could be a contracted service. And with regards to the like hours, I think that's a very good question. So it allows A&I to be flexible to help with situations where, for example, you have state employees staying until 8 p.m. to deal with a legislative committee. They could have exceptional hours during the legislature, which couldn't necessarily happen with a private provider that's only open 9 to 5, where they'd have to go get their kid, take them home, and then come back to the Capitol and be in front of us for a meeting. Hopefully that answers all of the questions.
Representative Davis.
Thank you, Mr. Chairman. Mine kind of short and sweet here. I don't believe we should take our taxpayer dollars and go in direct competition with enterprise. That's my say on it. I'm a no.
Representative Penn.
Thank you, Mr. Chairman.
On and against this, there's a lot of to unpack here, and it's only just barely starting to be attempted. In committee, when we heard this bill, we asked questions such as, how many kids do you anticipate? The answer was, I don't know. How is this going to be offered to just this city versus the surrounding areas versus the state? The answer was, I don't know. We asked, where is this going to happen? The answer was possibly somewhere on the complex. There are a couple of empty rooms around that we could probably use. Basically, the answer is, I don't know. No one cares about childcare probably in this room more than I do. I know this is a huge issue, and I appreciate the attempt. This bill has so much room to, we need to look into this a great deal more than what we have the opportunity to do here. The potential of this to have employees will come because there's childcare here. They will come, and so the numbers are going to be significantly higher than we anticipate. This would likely require, in my opinion, a facility all in and of its own with many staff, because the staffing ratios for daycares are very strict. There was a question about, do we offer this to our employees that work through the night or late and early hours? And I mean, there's just so many things. This will require a commercial kitchen. The cost of this idea is going to be astronomical. On and against.
Oh, Representative Clouston.
Thank you, Mr. Chair. I sit on this committee, and I just want to share the county that I'm from. Our hospital runs a similar program. It started in the hospital, and it grew to it needed its own facility. And the reason it grew is because it's helped attract employees, right? If one of your benefits of your job, and you're a young mom and you've got kids at home, is if you have a place that you can take your kids, it's a real benefit. It's also helped to retain employees. When I talk to some of our hospital trustees, they know some of their nurses and staff, which are in great need right now, are staying because they don't want to lose their child care. So I want you to consider this bill from a fact that we could retain and attract some employees based on this benefit. Thank you.
Representative Yin.
Mr. Chairman, thank you. So to answer the competition, I do want to say that we did have the organization that represents Wyoming businesses did have a testimony to us saying that this isn't that type of competition. And in fact, many private companies have their own childcare because it makes them competitive in the marketplace. We are at a lack of employees. I think we're doing a good job in trying to work towards that pay gap, but having a benefit that is, relatively small, and frankly, we'll find out what that cost is if this bill passes in the next budget. And if we don't like it, again, we just don't have to do it, but relatively small for the order of employees that we can provide this benefit, and they can say, when they're applying to the job, this is something that I'm looking for in a position that is consistent, and I know that I can raise a family. And folks who are currently working and married and younger say, oh, I can see myself staying in Wyoming, working for Wyoming long-term, knowing that there's a childcare option for me when I decide to start a family. And so the other benefit is that it actually provides a benefit for other organizations in Cheyenne that provide other citizens in Cheyenne that are not state employees, because it'll help open up a few more spots, because I'm pretty sure that even in Cheyenne, there's an issue with childcare.
All right. Question being called. All those in favor of Chairman Zwanenser's motion that when the committee of the whole rises a report that it do so with the recommendation that House Bill 206 do pass, signify by saying aye. Aye. Those opposed? No. The committee of the whole, House Bill 206 has passed the committee of the whole. Division being called. All those in favor of House Bill 206, please stand. All right, all those opposed, please stand. More than 18. It was really loud. It's really hard to hear up here, you know. Having failed a standing division vote, a roll call vote is required. The chief clerk will please call the roll.
Allemand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Clauston? Conrad? Crago? Davis? Eklund? Haroldson? Harshman? Heiner?
Hey, guys, when we're voting, let's be quiet and let's pay attention.
Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrop? Oakley? Obermuller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Penn? Provenza? Rodriguez Williams? Sherwood? Singh? Slagle? Smith? Stith? Storer? Strzok? Stivar? Tarver? Trujillo? Walters? Ward? Washit? Western? Wiley? Winter? Yin? Swanenser Dan? Swanenser Dave? Speaker Summers? Wiley, will you please repeat? Are there any changes? Brown? No to aye? Or aye to no? Berger? Aye to no? Further changes? Closing vote. Vote closed. 16 aye, 46 no.
Pursuant to House Rule 6-6B, House Bill 206 has failed a roll call vote and is indefinitely postponed. Privilege of the floor, Representative Allred.
Thank you, Mr. Chair. I would like to draw your attention to the south balcony here. One of my county commissioners, Kent Conley, is here visiting us. Thank you.
Next bill for our consideration is House Bill 172. The reading clerk will read the bill.
House Bill 172, sponsored by Representative Eklund. Evidence preservation, an act relating to criminal procedure. Mr. Speaker, your committee number 1 Judiciary, to whom is referred House Bill 172, evidence preservation, respectfully reports same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chestick, Nemec, Oakley, Provenza, Rodriguez Williams, Washit. Noes, Representatives Crago, Haroldson, Jennings. Representative Washit, Chairman.
For the reading of the bill, what is your pleasure, Chairman Washit?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with a recommendation that House Bill 172 do pass And I further move the Standing Committee Amendment Number 1 and turn over explanation of the bill to the sponsor, and we'll cover the Standing Committee Amendment at the appropriate time.
Chairman Eklund.
Mr. Chairman, I bring to you House Bill 172 and would ask for your favorable consideration on this bill. It's a constituent-driven bill. One of my constituents, when she was a minor, was assaulted. They collected a rape kit, and the perpetrator of this crime then shortly after that went to jail for child pornography. And then when he got out of jail, she married him and had more children. And then many years later, in a divorce and custody suit, has had some difficulties, and the evidence that was collected was disposed of at some point in time. The reason for the bill was to extend the period of time when the evidence would be kept. And so that essentially is what I've been trying to do. As we got into the testimony, I wondered if anything was being accomplished, because law enforcement was insistent that it was they would keep this evidence into perpetuity in most cases. But apparently it didn't work in this case, because it was thrown out. The evidence was thrown out. There was a little bit of confusion. I'll let the chairman of Judiciary explain. The meat of the bill is on page 2, line 2 through 5. And I will let the chairman of Judiciary explain the amendment.
Chairman Washit.
Thank you, Mr. Chairman. Members, if you turn to page 1, line 16 of your bill, we just added some language in there to make it clear that a court order could supersede the provision and the language of the bill. And then on page 2, line 3, we wanted to make sure that everyone was clear that we were talking about the victim and not just any person here, that we're talking to about the victim. So that's the committee of the amendment, and I urge your favorable consideration.
Question being called on Standing Committee Amendment Number 1 to House Bill 172. All those in favor signify by saying aye. Any opposed? Standing Committee Amendment Number 1 has been adopted, and we are back on the bill. Chairman Eklund.
Mr. Chairman, I do believe that especially the catch on allowing the court discretion in cases is a good thing to do. We just, sometimes you have to trust the court that they'll know what the right thing to do is. And I believe the bill would accomplish what I would like to see, and that is that evidence be preserved for a long period of time. In this case, it'd be till the death of the victim or 50 years. And there are no other questions on the bill or discussion. I would ask for your favorable approval.
Question being called. All those in favor of Chairman Washit's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 172 do pass, signify by saying aye. Any opposed? House Bill 172 has passed the committee of the whole. Next bill for our consideration is House Bill 160. The reading clerk will read the bill.
House Bill 160, sponsored by Representative Pendergraft. Driver's license veterans designation replacing DD Form 214, an act relating to Defense Forces and Affairs. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom is referred House Bill 160, driver's license veterans designation replacing DD Form 214. Respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Berger, Brown, Nemec, Obermueller, O'Hearn, Pendergraft, Smith, Stivar, Wiley. Representative Brown, Chairman.
heard the reading of the bill. What is your pleasure, Chairman Brown?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with a favorable recommendation on House Bill 160 and that it do pass. I further move the standing committee amendment, and if it's okay with the bringer of the bill, I'll just dispose of that really quick. Ladies and gentlemen, this is just a little bit of a cleanup amendment, and it basically just inserts Wyoming in front of driver's license as well as identification card. And then I'll call for the question on that if there's no discussion on that, and turn the explanation over to the good representative from the center part of the state.
Question being called on Standing Committee Amendment number 1 to House Bill 160. All those in favor signify by saying aye. Any opposed? Okay, Standing Committee Amendment number 1 has been adopted. We're back on the bill. Representative Pendergraft.
Thank you, Mr. Chairman. This is quick and easy, folks. As many of you know, if you are a veteran, you can get a V or a veteran designated on your driver's license if you show them a DD-214. Therefore, to me, it follows that in subsequent places, if you show that ID card with the V on there, it's the same as having a DD-214. There is an exception, at least one, and that is by county treasurer's offices. And that language on page 2 of this bill under paragraph B addresses that, which says that they are welcome to ask you to go ahead and present your DD-214. It's just a matter of convenience so that veterans such as myself can very quickly verify our status without having to run home and open the gun safe and pull out our DD-214. With that, I ask your favorable vote on this bill.
Question being called. All those in favor of Chairman Brown's motion that when the committee of the whole rises to report, it do so with the recommendation that House Bill 160 do pass, signify by saying aye. Any opposed, no. House Bill 160 has passed the committee of the whole. Next bill for our consideration is House Bill 147. The reading clerk will please read the bill.
House Bill 147, sponsored by Representative Provenza. Unlawful trespass signage, taking of wildlife, an act relating to game and fish. Mr. Speaker, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom was referred House Bill 147, unlawful trespass signage, taking of wildlife. Respectful report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representative Angelos, Burkhart, Byron, Larson, Singh, Storer, Western, Winter. Excused, Representative Newsom. Representative Western, Vice Chairman.
You've heard the reading of the bill. What is your pleasure, Vice Chairman Western?
Thank you, Mr. Chairman. I move that when the committee of the whole rise to report, it do so the recommendation that House Bill 147 do pass. And I turn over, I believe there is a standing committee amendment, and I move that amendment. And I'd like to turn over the explanation of the amendment and the bill to the representative from the good college town.
Minority Whip Provenza.
Thank you, Mr. Chairman. I bring to you House Bill 147, unlawful trespass signage. Committee, this bill is a product of personal experience and also hearing from constituents and talking with hunters across the state that have run into issues in running into trespass signage on public land. So landowners who are presenting trespass on parcels of land that they don't own, that belongs to the people. For those of you that hunt, I imagine that you have run into this issue. As I've heard many people say that they have, you're in the process of chasing an elk, you're creeping over a knob, or you're going through the trees and you think you're on the right path to get your game, and it ends up that there's a property sign there that you're like, well, I know better. I've been on my program that coordinates where private landlines are, and this isn't supposed to be one of those places. But because hunters are careful about how they deal with these issues, oftentimes they don't want to go past that private property sign because they don't want to be wrong and accidentally trespass. So what this does is really, in Article 1, Section 39 of our Wyoming Constitution, it states that the opportunity to fish, hunt, and trap wildlife is a heritage that shall forever be preserved to the individual citizens of the state of Wyoming. And so I would argue that this is an issue in which we are keeping folks from being able to lawfully hunt. So what the bill does in general, and before I get to the standing committee amendment, is it's housed under our statutes that deal with the agency that works with our incredible wildlife and fish that are in our crystal clear waters. What it's doing is making it so that under this statute, which is 23-3-405, this is interference with lawful taking of wildlife prohibited. The background on this is that this bill, or the statute, was created in 1991 to deal with folks that were kind of getting in the way of lawful hunting. That might be, you might think of agencies that don't like hunting as being one of those. And it created a, sorry, I dropped my papers, everybody. Didn't disappear. So what we're doing is making it so that under this statute, part of what that is trying to get in the way of lawful hunting. So the whole section of the bill, what we do is we have under under paragraph A on page 2 is knowingly and without authorization post signs. So this isn't meant to go after landowners who accidentally post signage. It's not meant to be a gotcha on anyone. What we're trying to do is make it so that the agency that earns most of its funding from hunters and anglers is able to also assist with them. I think 90% of these issues will just be handled by a phone call rather than actual criminal or citation issuance. Then that last part, paragraph G on lines 11 through 13, not interfere with any landowner's right to prevent criminal trespass on the landowner's private property. So that's the bill body, and I will stand for questions.
Questions on the amendment? Or do you want to, the amendment's already been moved. Do you need to discuss the amendment? Representative Provenza? Representative Grego?
Thank you, Mr. Chairman. On the amendment, question on the amendment, lines 13 and 14, section 2, it says this act shall not apply to fences placed by a landowner before the effective date of this section. Could someone explain to me what the purpose of that language is within the bill, why it's there, and how that relates to notice of trespass or trespassing notice signs?
Representative Provenza?
Thank you, Mr. Chairman. And to, go into that amendment, sorry, I didn't give a clarification on this. So what the amendment does is several things, but what the good country lawyer is referring to is this exception that we put in because there was conversation on the northeast part of the state about some kind of landowners that have been there for quite some time. Their lines might not match up. There was concern in the committee about that. Although I will say that in the bill itself, this does have to do with signage, not so much fencing, so that might be taken care of in the bill, but that will be up for the body to decide. So that was the point of that, was that maybe a line or a fence is 100 feet from where it should be.
Vice Chairman Western on the amendment?
Thank you, Mr. Chairman. On the amendment, I think just to provide some clarification, the intent behind that language was just to make sure that ranchers who do post signs, again, we're not pointing fingers, we're not imputing intent, but in the event there was a sign that was posted perhaps on some state land or federal land, that they are not, certainly not liable. To the literal language of the amendment, that's an oversight by the committee. Obviously, it should read signage. So I encourage the body to adopt this amendment so we can come back on a second reading amendment and get that language the way it's supposed to read. So thank you.
Further discussion on the amendment? Question on the amendment? All those in favor of standing committee amendment number 1 to House Bill 147 signify by saying aye. Any opposed? The standing committee amendment number 1 is adopted. We're back on the bill. Speaker Summers.
Mr. Chairman, thank you. And you know, your standing committee amendment kind of brought up one of the issues. Is I think of our ranch and all of the old fence lines that are on our ranch. None of them are online. I mean, none of them. They may cross the line, but they're not online. And so I worry about what is knowingly. So does knowingly mean that I was told once the sign should go down? Or does knowingly mean that I should have known, I should have known because it was my fence? And then again, what is the penalty? So if I violate this, which I've got some no trespassing signs up that might be on fences that cross other lines, so what does that mean? Am I going to be fined, or do I just have to take my sign down? I guess, we get in this fight every session on the word knowingly, and I don't understand how it will apply in this situation. So all the good lawyers in the room can somehow explain to me how knowingly is going to fit into this. They say they don't want to, so perhaps we can just vote and move on, but I am curious.
Could be a long afternoon. Representative Provenza?
Thank you, Mr. Chairman. And to answer the question about penalties, what happens, those are listed under 23-6-202. On this first offense, what we're going to see is what would be under the Section 23 statutes as a low misdemeanor. So I think the low misdemeanor is up to $1,000 and may be added imprisonment of up to 6 months. Very unlikely. What's likely to happen is, hey, you got your sign in the wrong spot. Can you move it? Oh gosh, yes, I will move the sign. So that's the most likely thing. In terms of knowingly, I love that our good speaker wants to be here until 3 o'clock in the morning. But I will say what knowingly does, and what is included on paragraph A of this bill, is this: no person shall with the intent, and then knowingly. So what this does is protects the landowner from knowing, or from, if they maybe misplaced the sign, or they didn't have this intent to keep people from using that public land, we don't want them to be subject to any of these citations. So knowingly, we're knowingly trying to protect unknowingly landowners.
Speaker Summers?
Mr. Chairman, thank you for the follow-up. And I don't know the answer to this, though I should. So let's just say you trespass on my land. So if you trespass on my land, what is the penalty? Versus what is the penalty if I have a sign up that violates this bill? So in other words, it seems like there's this trespass, there's actually a knowingly trespass, right? If you've already done that offense once, or if you've been told that you can't trespass, then there actually is a trespass violation. But if you don't know, as I recollect, I don't think there is a trespass. Really, there's trespass, but there's no penalty. So does that make any sense if that is in fact the case?
Representative Provenza?
Thank you, Mr. Chairman. So if in our statutes that deal with the department that oversees our wildlife, intent is often not part of the statutes. So it's enough that if you are a hunter, the burden is on you to know where you are. So if you trespass as you are in the process of taking wildlife, which is hunting in any way, then what ends up happening is that you are in, I believe, this would be a violation of our 23-3-102, taking certain game animals without license or during a closed season prohibited. Well, I guess that's the taking of. But then we have the the Title 23. 23-3-305. This is hunting from highway, entering enclosed property. What this does, I believe this takes us back to so no person shall enter upon the private property of any person to hunt and so forth. Violation of this subsection constitutes a low misdemeanor. So it would be equivalent to what we have, right, for what we're trying to do here. So that's part of the discrepancy that exists in current law, is that we have something for people who trespass on private land, for hunters in our in these statutes, but we don't necessarily have something for landowners that get in the way of the lawful hunting. So penalties would be the same.
Oh, Representative Alleman.
I'm sorry, Mr. Chairman, I'm very concerned with this bill. And the reason why is if a landowner runs a hunter off and maybe even serves a trespass on him, that hunter can sneak back that night or in the near future, put the sign on, take pictures of the sign and blame it on the landowner. Thank you.
Representative Strzok.
Thank you, Representative. Privilege of the floor.
We don't typically do a privilege in the middle of.
Oh, I can't.
Yeah, you'll have to wait
Okay.
until between the bills.
I am so sorry.
It's okay. Further discussion on this bill. Representative Craigo.
Thank you, Mr. Chairman. I think in response to what the good speaker was asking about, and I think what he was trying to get to is under trespass, you get notice. Otherwise, you aren't considered a trespasser unless you're there strict. If you're there hunting, you don't get notice. But if you're required to know where you are. But if you're there under the criminal statute, you get notice. And I think what the knowingly part, and maybe we could work on some language for the second reading to try to fix that. As I read this, the knowingly means you were given notice or you knew that the sign shouldn't be there. And I've thought about this as I've read this bill several times, and I think there's a way to probably fix that language so that, the intent is if you have a sign up, for example, as a landowner on your fence, law enforcement comes to you and says, hey, you got the sign in the wrong place, you don't take it down, or you take it down for that day, and the next day you come back and put it back up, that should be a crime. And I think that's what we're trying to get to. I think that's what the good sponsor's trying to get to, and I think we can make that happen. We might take a little work of the language, but I'd on in support of the bill.
Question? Okay, question, no? Representative Western, you're leaning on that podium pretty heavily. Okay, all right. Question being called, all those in favor of Vice Chairman Western's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 147 do pass, signify by saying aye. Aye. Any opposed? No. House Bill 147 has passed the committee of the whole. Representative Strzok, where are you? Would you like your... Oh. Privilege of the floor from up in the balcony. Yay! Welcome to the House of Representatives. Always a delight to have family members visiting during our good work. Our next bill for our consideration is House Bill 119. The reading clerk will please read the bill.
House Bill 119, sponsored by Representative Penn. Medical prescriptions, off-label purposes. An act relating to professions and occupations. Mr. Speaker, your Committee Number 10, Labor, Health, and Social Services, to whom was referred House Bill 119, medical prescriptions, off-label purposes, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Klauston, Hornock, Penn, Trujillo, Ward, Swanitzer. Noes, Representatives Chadwick, O'Hearn, Yen. Representative Swanitzer, Chairman.
Heard the reading of the bill. What is your pleasure, Chairman Swanitzer?
Thank you, Mr. Chairman. I move in the Committee of the Whole rise to report it do so with the recommendation that House Bill 119 do pass. I would further move the Standing Committee amendment and turn it over to the good representative from Fremont County.
Representative Penn.
Thank you, Mr. Chairman. If I may provide a little bit of background on this, and then I'll take you through the amendment and the bill. So what we're talking about here is off-label medications. So 20 to 30% of all medications that are prescribed are actually done so for off-label purposes currently. So it's not illegal to prescribe off-label. off-label means that the drug wasn't FDA tested specifically for that use, that use isn't listed on the label, but it has undergone still the FDA authorization process. So what does the FDA actually do in this process? They focus on the market entry of the drugs, making sure that they're safe and that we understand what they do. They consistently maintain that they don't regulate the practice of medicine between physicians and patients. FDA clearance mostly ensures physicians that a drug effectively produces the actions to treat a specific illness. But it's the physician, not the FDA, that determines whether these specific effects will be useful for a particular patient. So why is it that we are here today discussing this? Why do we need this? So COVID did a lot of things for us. A lot of things were great. Well, a few things were great. A lot of things were not great. But one of the things that it helped us identify was a little bit of a hole in this off-label prescribing. Like I said, it's typically been done it's done all the time, every day. But what COVID identified was that, well, with that, there were providers that were threatened with loss of employment. They were threatened with discipline if they were to prescribe medications. And the reason that was given for those threats is that, well, that medication's off-label for COVID. It hasn't been tested in COVID, so we don't know if it's safe. But what that did is that, so there were people within Wyoming who lost their jobs for this. But even more than that, it put a stigma so that a lot of providers just were simply unwilling to do it because it was, put out there as being off-label. And that was, again, given that was the reason for the stigma, I suppose, but it cut off the access of patients to what potentially were, and some deemed as, life-saving medications. And so that's really what I'm trying to do with this, is protect that relationship and the ability for a patient to continue to go to their doctor and have those conversations and decide with that discussion, decide what is right for them. So we'll go through the bill. On page 2, there's definitions. So disciplinary action is revocation, limitation, suspension, or denial of a license. We already discussed the definition of off-label. On page 3, paragraph A means that it says that a prescriber may lawfully prescribe a prescription medication off-label indication. And then with our amendment in committee, we added within the scope of practice. So that gets us away from, a dentist attempting to prescribe chemotherapy or, things like that, within scope of practice, which I think is a reasonable amendment here. This also includes pharmacists that they're authorized to dispense as long as there is a valid prescription order. This does not apply to Schedule drugs 1 and 2. So Schedule 1 and 2, which would be narcotics and things of that nature. Schedule 1 are not actually things that are legal to prescribe in this state anyway. So it doesn't apply to those things. On page 4, this paragraph says basically that no adverse action will be taken against a prescriber or pharmacist strictly because of the prescription was off-label, and that's very important. In fact, the words in the bill say solely on the basis of this. So you can't come after a doctor afterwards and say, well, this was off-label, and that's the only reason you're coming after them. We're not talking about negligence. We're not talking about that. Strictly, solely on the basis of this being an off-label drug. It's not unprofessional for doctors to recommend or prescribe or give opinion on COVID treatments. And then the final clause there is the immunity from civil liability. And in our discussions with the agencies, that was of great concern. And so the amendment actually takes that immunity from liability out. I think there was one thing that I skipped over on another thing that we added with the amendment line, or page 4, line 15, the phrase that informed consent has been obtained. And that does say in writing. So do we move the amendment?
The amendment's already been moved.
Okay.
Are you ready do you need discussion on the amendment, or are you ready for the question on it? Question on the amendment, Standing Committee Amendment number 1 to House Bill 119. All those in favor signify by saying aye. Any opposed? Standing Committee Amendment number 1 to House Bill 119 has been adopted, and we're back on the bill. Speaker Pro Tem Stith?
Mr. Chairman, so my question here is, it's my understanding that off-label prescription drug use is currently lawful in our state right now. And so I'm really curious about how the immunity provision works. Let's imagine I'm a physician and I prescribe a drug that's, of course, off-label for an off-label use, but let's imagine that my prescription, I just make a mistake and I prescribe fentanyl for someone who, doesn't warrant having fentanyl, and I kill them. And it was just a big screw up on my part. Like I should never have, as a physician, I should never have done that. It's off-label for fentanyl. I prescribe it. I kill the patient. If this bill passes, then am I immune from, my responsibility of killing that person?
Representative Penn?
So, excuse me, the immunity clause was.
Just a reminder to go through the chair
Oh,
as well.
excuse, Mr. Chairman, thank you. The immunity clause was removed with our amendment.
Chairman Eklund?
Mr. Chairman, and I think this is a good bill, just to bring some more light to it. It has been done a lot long before COVID. There are a variety of medications that after they're tested and they start using them on one thing, they find out they have desirable side effects. And like one of them would be pain relief, one of them would be as a sleep aid that I know of, and there's probably more, but it just allows the physicians a little more flexibility and another tool to treat patients. And I think that it's something that if we need in place, it isn't just because of COVID.
Representative Larson Lloyd?
Thank you, Mr. Chairman. I had a conversation with a family member who has the authority to prescribe, and it was interesting that they said that for some, they found that some antidepressants didn't work really well, but they really helped traveling diarrhea, and so they use them for, she was giving me a number of these things that they use for off-labeling, and it's commonly used, so it works. And I think our medical profession have come to understand some of these things as they've seen some of the positive side effects from some of these pills and sleep aids. My question to the bringer of the bill, she referenced several times that when they come after them, I don't know what that means. Who's coming after who and why? Is it the licensing board that is then saying to the prescriber that they've violated something? I'm not understanding that they're coming after them. Makes me get scared.
Representative Penn?
Thank you, Mr. Chairman. To answer the good representative's question, we heard testimony in committee that of individuals who lost their jobs, so their facility prevented them from prescribing specific medications with the justification that they were off-label, while at the same time still allowing medications for treatment of COVID, which were also off-label. Given the scenario here, because what it takes to become on-label is years of testing, really no medications that we used initially for the treatment of COVID were on-label. Everything was off-label, but specific ones were identified as not allowed. So there were individuals who lost their livelihoods for continuing to prescribe what they felt like was a worthwhile medication.
Minority Floor Leader Yin?
Thank you, Mr. Chairman. So if this was only about protecting physicians or other prescribers from employers, I probably wouldn't have a big deal with it. The big issue with it, well, the civil liability was the biggest issue, which is gone now, which is great. But on page 4, we're talking about professional conduct. And what this does is it creates a hole with how the licensing board, so the Board of Medicine, oversees its physicians or other prescribers et cetera, or the Board of Pharmacy and how it looks after pharmacists. And the licensing board, I want to make this really clear, the reason they exist is to protect the safety of us, the citizens of Wyoming, to make sure that the high standards of what it takes to be a doctor, a physician's assistant, a nurse, a pharmacist are held to a high standard. The boards all came to us, so those 3 boards that oversee those groups all came to us and said they never issued any disciplinary conduct, any disciplinary action against any provider for the 2 drugs in question over COVID-19, ivermectin and HCQ. None of those were issues. So what becomes an issue is because this bill covers all off-label medications that aren't Schedule 1, Schedule 2, so like ketamine, Valium, it creates a hole where the licensing board no longer
Point of
has an
order.
authority.
Point of order, what's your point?
Maybe I just need a
Representative Swanson?
ruling on proper names. In previous years, medication names were out of bounds, so I just want to make sure we're allowed, because those are products that are private company produced. I'm not sure if using medication names are allowed or not, so.
They're not in the bill?
They're not in the bill, Mr. Chairman. no.
They're not.
Minority Floor Leader Yin?
Mr. Chairman, I apologize, and I will withhold from mentioning those drug names going forward. But again, I really do want to highlight that this creates a mechanism where the licensing board can no longer regulate its own physicians that it licenses if they prescribe other medications that are more dangerous than the 2 medications that were considered alternative medications for COVID-19. So we are really talking about drugs with higher side effects like ketamine, like Valium. Sorry.
Representative Yin.
Mr. Chairman,
One more
thank
and I'll
you.
hold you in contempt.
Mr. Chairman, thank you.
I'm just kidding. I'm just kidding. I don't have that much authority. Please proceed.
We're talking about more dangerous drugs that could be prescribed off-label. And I take off-label medication myself. It isn't necessarily a bad thing, which is why there was no disciplinary action, because doctors do have wide authority. But if a doctor starts making prescriptions for a bunch of patients and they're a pediatrician and making prescriptions for adults that are trying to use medications recreationally, the licensing board no longer has authority over that. Even with the amendments we made in committee, where you have informed consent, I can have informed consent and say, yes, I do want those drugs. I think those are great, but that doesn't mean that it's ethical for a licensed physician to continue doing that, and then the licensing board no longer has authority over it. So that's the biggest issue for me, is the licensing board hole that we've created in this bill.
Representative Trujillo?
Just a tidbit on, through you, Chair. Tidbit on also testimony that we heard in committee. We heard from 2 people that weren't given an option on medication that they were given. And actually one testified as it was a family of 3, and they were forced to take medicine that was only available according to, I'm not exactly sure, but the husband died. The son has kidney failure and is on medication, and the wife was also very sick. And on the second one, we heard of another testimony of a guy who was given the medication because he wasn't given an option on what he could take. And he also was suffering from kidney failure and kidney disease and was hospitalized. So weighing out both sides, there's nothing wrong with this bill, and I'm pretty sure the boards could probably adjust.
Representative Ottman?
Thank you, Mr. Chairman. Just some food for thought. As a private citizen, I don't have a lot of television. And so coming to Cheyenne, I've been able to watch television. The commercials that are on with all the side effects about FDA-approved drugs is phenomenal, just phenomenal. And it's all during the time of people playing music and doing sports and doing all these things. And I'm just like, oh my gosh, what a lot of things that could really have a lot of things that would make it worse for me. So as I'm thinking about this bill, I am so thankful that I don't have a lot of these problems at the time to be diagnosed and to be given these things. But what I do know is that when I do go to the doctor, I ask for them to speak with me, to know my desires, to know my health conditions, to know what I want, and to work with me to prescribe the things that I want. And I believe that this bill does that. It protects the medical freedom of patients to be treated as they desire. The other thing is that it also, well, there's 2 states now, New Hampshire and Minnesota, that are bringing bills like this. So it is something that's been being looked into. So on and for the bill. Thank you.
Question, all right. Question being called. All those in favor of Chairman Zwanenser's motion that when the committee of the whole rises to report it, do so with recommendation that House Bill 119 do pass, signify by saying aye. Those opposed, no. House Bill 119 has passed the committee of the whole. Next bill for our consideration is House Bill 103. The reading clerk will please read the bill.
House Bill 103, sponsored by Representative Haroldson. Political party affiliation, declaration, and changes. An act relating to elections. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred House Bill 103, political party affiliation, declaration, and changes, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chadwick, Haroldson, Harshman, Knapp, Newsom, Olson, Ottman. Noes, Representative Yen. Excused, Representative Wiley. Representative Olson, Chairman.
Representative Olson, what's your pleasure?
I move that when the committee of the whole rises to report it, do so with the recommendation that House Bill 103 do pass, and I further move the adoption of Standing Committee Amendment number 1 to House Bill 103, and I'll turn over the explanation of both the Standing Committee Amendment and the bill itself to the sponsor from the land north of where we are, I suppose. That's the best I could come up with at this hour.
Representative Haroldson.
Thank you, Mr. Chairman. I'm moved by that. Thank you. You can hear me? Okay. Well, before us today, we have House Bill 103, and House Bill 103 is, to bring it into layman terms, a bill that will address crossover voting. And this is a bill that 2 years ago I ran, and we've saw it last year as well come out of the Senate side. 2 years ago, the conversation was, we don't know if this is even an issue. And then last year was, we think this could be an issue. And then this year we're standing here going, wow, it actually was an issue. This is something that came forward and we saw it as an issue. And so House Bill 103 would make it where to cross over from party to party would require the individual making a decision as it currently stands before the amendment prior to the date of filing for elected candidates. With the standing amendment, the committee amendment, it would be 45 days before primary. And so I'm explaining that so you guys can get this perspective and we can just make a decision on which way we want to go on this. Because again, it's policy. So there is right now a petition being signed by citizens looking at trying to establish this because they felt, I mean, just being honest, that we didn't accomplish that, so they're trying to accomplish that. And they're looking for the 1st of May. So again, a policy. So the standing committee amendment would be a 45 days before primary. Without that, it would be the day of, first day of filing. And so at that time, at this time, I'd like to kind of have discussion on the amendment and or call for the question on the amendment if that's something you guys want. Really, this comes down to, do we want it to be that May 15th date, or do we want it to be 45 days before the primary? My personal opinion, the May 15th date, so we don't add mud into our water. But at the same time, again, that's a decision we need to make here on the floor. So,
Speaker Summers.
Mr. Chairman, thank you. On and in favor of the standing committee amendment. I looked up elections some time ago and I had staff do a history of it. When we put in this primary system in 1911, it was actually 10 days. And I think our election system has served us pretty well for a long time. So frankly, I don't think that we even need a change, but if we need a change, I think it needs to be more like it was when it came in, which was 10 days. So on and in favor of 45 days in the amendment.
Question being called on standing committee number 1 to House Bill 103. All those in favor signify by saying aye. Aye. Any opposed? No. Okay, standing committee amendment number 1 has been adopted. We're back on the bill. Division being called. All those in favor of standing committee amendment number 1, please rise. This is going to be a close one. Go ahead and sit down. All those in favor, all those not in favor, please rise. All those opposed. Remain standing. Wow, on a vote of 30 to 31, that amendment has failed. We are back on the bill.
Okay, back on the bill. So how it stands currently is it would be the May 15th date and then 14 days before the general. And this right here we got testimony in committee that this would cease the citizen movement that is going on currently in our state. This is what they're looking for. This is what they're asking for. So they gave testimony that if we pass this out of this body and we make this into statute, that this is what they're actually looking for. So anyways, I believe that's a pretty easy bill. It's pretty simple in how it lays it out.
Representative Chestick?
Thank you, Mr. Chairman. On and against the bill. As a member of the minority party, I don't necessarily think that the bill as proposed will accomplish what the majority party wishes to accomplish. I know that there are many members of the minority party who actually do register as members of the majority party because there's a belief that sometimes the only election that matters is the primary for the majority party. And all this is going to do is encourage more people from the minority party to simply permanently register as members of the majority party. And I'm not sure that's what you're trying to accomplish here. So I want to preserve the right of all voters to express their will and vote in whatever party primary they think is appropriate, and I am against this bill.
Representative Stivar? No? Okay, further discussion? Question being called on this bill. All those in favor of Chairman Olson's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 103 do pass, signify by saying aye. Aye. Those opposed, no. House Bill 103 has passed the committee of the whole. The next bill for our consideration is House Bill 185. The reading clerk will please read the bill.
House Bill 185, sponsored by Appropriations. Local Government Distributions Revisions, an act relating to local government funding. Mr. Speaker, your committee number 2 appropriations, to whom is referred House Bill 185, Local Government Distributions Revisions. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
For the reading of the bill, what is your pleasure, Chairman Nicholas?
Thank you. When the committee will rise and report, I do so with a recommendation that House Bill 185 do pass, and I will explain the bill to the floor. It's really simple, ladies and gentlemen. What your Appropriations Committee did was add basically $13 million to the cities and counties. Normally it's 105 million, and this adds another 13 to that list. You may also recall that previously there was added 15 million, but the 15 million had a different distribution, and more went to the smaller communities. So with this additional 13 million, that will go to a combined total of 133 million, and the 13 million that we're adding here is under the original distribution. We now have for the 105 million for local governments. So appreciate your support.
Okay, question being called. All those in favor of Chairman Nicholas's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 185 do pass, signify by saying aye. Any opposed, say no. House Bill 185 has passed the committee of the whole. Next bill for our consideration is House Bill 19. The reading clerk will please read the bill.
House Bill 19, sponsored by Tribal. State Indian Child Welfare Act Task Force, an act relating to children. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred House Bill 19, State Indian Child Welfare Act Task Force. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chadwick, Clouston, O'Hearn, Penn, Trujillo, Ward, Yin, Zwanitzer. Noes, Representative Hornock. Representative Zwanitzer, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Zwanitzer?
Thank you, Mr. Chairman. I move in the committee of the whole rise to report do so with the recommendation that House Bill 19 do pass. There are no standing committee amendments, and I return it over to the good Vice Chairman of Appropriations.
Representative Larson Lloyd.
Thank you, Mr. Chairman. Folks, this bill is dealing with a task force, and I think we need to clear the air right at the beginning. You don't like task force. I don't like task force, but there are times when we have them and they really provide a benefit. And this is one that I would really encourage you to support. And it goes back to a discussion that we've been having in select tribal relations. There's a federal law, the Indian Child Welfare Act, that came into play in 1978 that seeks to keep Indian children with Indian families as it was passed. Prior to the passage, and we'll refer to that law as ICWA, prior to the passage of ICWA, approximately 75 to 80% of all Indian families living on reservations lost at least one child to the foster care system of the state. Now, since the implementation of ICWA, some states, it's a federal law, and the interesting thing about ICWA is most states reserve the right to administer child protective services as a state law. And so there's always been a little bit of pushback as the feds are dictating what we can do as a state. The other part of this federal law that has been a little bit of an angst to people is they look at and they say, why is it that our Native American tribes have this right that they can intervene in child protective service issues and other races can't? And ICWA establishes that this isn't a race, but it's a political entity, and they're sovereigns, and as such, they have the right to do so. And so the essence of ICWA was that if you lived in the capital city down here, and if I were a member of federally recognized tribe. And something happened that there was a court case that would perhaps take my child away from me. The courts are required to notify the tribe for which I belong, could be in state, could be in another state, and determine if they would like to take jurisdiction or maintain concurrent jurisdiction with the district court here, but that they have the ability to determine where that child goes, may go back, may get placed here in a foster family, may go back and get placed with family wherever that tribe exists or some other entity within that. The important component of that is this has protected the culture and the sovereignty of the tribes as they've watched their children prior to ICWA try to be assimilated outside their culture. And it really became a big problem. ICWA's tried to maintain the pendulum swinging from too far one way and too far to the other. The reason for this conversation today is that the Supreme Court has decided that they're going to listen to arguments and decide whether to overturn the federal law or parts of it or maintain it. The reason that that's important here is because Wyoming, our state, has complied completely with the federal law. It has not adopted any component of that into state law. So we don't have a state ICWA statute. Other states have. Some of those states have not done a good job at that, and others have. As we listened in tribal relations to entities outside who are the experts on ICWA, they point out that the federal law has some problems that would be appropriate for a state to adopt. And of course, the downside of some states have not adopted good laws and they conflict with the federal law. So at the end of the day, this bill puts together a task force that brings together legislature, tribal members, and people from the legal profession that deal with this, and to decide and come back and recommend to you as a legislature, should we put into place a state ICWA law or any part of it or none of it. For a state like Wyoming that has the Wind River Reservation and these two tribes and the surrounding tribes around it, this is a pretty big deal that we need to make a motion on. So that really is the essence of the bill, Mr. Chairman, and I would be happy to try and answer any questions.
Question being called. All those in favor of, Representative Hornock.
Thank you, Mr. Chairman. So just a couple of notes that I want the body to think about before we vote. I listened to this in committee and I was the only vote against this, and I'll tell you why. Just because I think we're slightly jumping the gun here. I don't mind a task force, and if the Supreme Court does away with ICWA or whatever they do with ICWA, I think we're going to need to figure that out. But I think the time period that's within this bill, we're slightly jumping the gun. The Supreme Court's going to, I'm sorry, am I allowed? The court is going to hear.
You're fine.
Hear arguments pertaining to this later on this year. Then we have a finite time between the enactment of this task force and their results to come to a conclusion. I think we're about 1 year ahead. That's all I'm saying on this, because by the time these interim committees meet, this task force meets several times, I just don't think by the time the court comes down with their final ruling on what's going to happen with this process, I think it doesn't give us very much time at all to figure out what we want to do and to enact legislation if that's the way we want to go. So I just think that the time frame on this just doesn't seem to work out with the task force. I do think that we need to wait for the court ruling to figure out really the direction that we want to go with this. So that's why I vote no on this, and I'll leave that decision up to you guys. Thank you.
Any further discussion on this bill? Question being called. All those in favor of Chairman Zwannitzer's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 19 do pass, signify by saying aye. Aye. Any opposed, no? No. House Bill 19 has passed the committee of the whole. The next bill for our consideration is House Bill 124. The reading clerk will read the bill.
House Bill 124, sponsored by Representative Summers. Electricity generation, taxation, an act relating to taxation. Mr. Speaker, your committee number 2 appropriations, to whom is referred House Bill 124, electricity generation, taxation, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Stith, Walters, Zwannitzers. No, Representative Sherwood. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chairman. I move when the committee of the whole rise and report it does so with a recommendation that House Bill 124 do pass, and turn the explanation over to the good speaker.
Thank you. Speaker Summers.
Mr. Chairman, thank you. Ladies and gentlemen of the 67th, I bring you House Bill 124 and ask for your favorable consideration. This bill is about equity and taxation. Currently, wind energy is taxed, coal and natural gas are charged severance tax, but solar isn't paying a similar tax. Why should solar have a tax advantage over wind? This bill levels the playing field between solar and wind by taxing solar the same as wind at $1 per megawatt per hour. I will walk you through the bill. We simply go into Chapter 22, 3922-103, imposition. And you can see on page 2 of the bill, anywhere there's wind, it goes and solar. And it kind of does the same thing in 3922-107, compliance. Section 2 shall apply to any electricity produced from solar resources for sale or trade on or after January 1st, 2024. So it puts it out till January 1st, 2024. Section 3 is the effective date of the act, which is July 1st, 2023. July 1st, 2023. This bill does not affect rooftop solar, so solar that is used for personal use. And so if you go into the basically into the statutes on wind, which this is where solar will lie, it says in 3922-105 exemptions, no tax shall be imposed upon electricity which is produced from a generating facility owned or operated by the federal government, state of Wyoming, or by any county or municipality in this state. No tax shall be imposed upon electricity which is produced for the personal consumption of the producer, including any excess production of electricity that does not exceed 500 kilowatts per hour in any 24-hour period. I did a little looking on the internet, and it appears that if you had a 1,700 square foot roof and you have 5 hours of direct sunlight, which is kind of the average for the U.S., you might generate 155 kilowatts per day. So with that, I guess just to clean it up, I just think this is an equity issue. I think renewables ought to pay their fair share. So I'd stand for any questions.
Representative Conrad.
Mr. Chairman, thank you. Question for the good ring of the bill. Specifically, have we considered, and first off, let me preface this by saying that I am absolutely on board with the equity component. My concern is, as we look at the amount of revenue that's potentially lost in terms of capital expenditures, et cetera, so forth, have we considered the overall formula and the businesses that we lose, specifically those solar installers, I should say, the jobs we lose, specifically when those respective solar farms go to an abiding state or adjoining state in this case, one specifically to the west of us. I'm just concerned about are we limiting, or more importantly, reducing the opportunity for jobs, et cetera, so forth, and economic development by promoting this, that we may lose an opportunity if we do begin taxing the solar producers and or installers. Thank you.
Representative Wiley.
Thank you, Mr. Speaker. Coal taxation. oil and gas, taxation. Every commodity, taxation. Solar, zero taxation. Folks at home, my constituents, a lot of them are in power generation. A lot of them burn coal. This is a fairness thing. I believe solar doesn't get a ride the wagon and drag their legs. Everybody has to pull. I'm on and for this bill. Thank you.
Speaker Summers?
Just quickly on the issue of economic development. I heard the sky was falling when we instituted the wind tax. The sky didn't fall. We've got lots of wind projects. I expect the same will happen with solar.
All right, question being called. All those in favor of Chairman Nicholas's motion that when the committee of the whole rises to report it, do so with recommendation that House Bill 124 do pass, signify by saying aye. Any opposed, no. House Bill 124 has passed the committee of the whole. The next bill for our consideration is House Bill 99. The reading clerk will read the bill.
House Bill 99, sponsored by Revenue, Property Tax Refund Program, an act relating to property tax. Mr. Speaker, your committee number 3, Revenue, to whom is referred House Bill 99, Property Tax Refund Program, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Swanitzer. Representative Harshman, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Harshman?
Thank you, Mr. Chairman. I'd move that when the committee of the whole rises to report, it do so with the recommendation on House Bill 99 do pass. I'd also move a recommendation do pass on the standing committee amendment. And to explain the bill is the good representative from the land of Fremont. I don't know, that didn't come out right.
That's a lot. No, it came out a lot better than mine, so you did good. Representative Oakley.
Thank you, Mr. Chair. I have indeed a good little bill here that to wrap us up. And before I go over it, I just wanted to say this is it's the property tax refund program. So it's one of the many ways we're looking at addressing probably what all of us heard on the campaign trail some this summer from people from Wyoming Heights and constituents that they're looking for, different forms of property tax relief. So what I'd like to say is this is a program that already exists. It's been around for, what do we think, 30 some years, probably one of the better tax refund programs that we've had. Okay, so going to the bill, what this does is amend the qualifications to apply and then get accepted to the program, and also do some amending for the qualifications for the county optional program, because again, this program already exists. And I'll talk about it at the time, but so there's 4 counties who currently are taking advantage of it. So we've got some changes there too. Again, this has been in statute for a long time, 3913-109. So on the bill, page 2, the 2 things you see on page 2, pretty simple, more like language cleanup. It said showing that he is qualified, change that to showing that the owner or an immediate family member of the owner. Same language on lines 14 through 15, so what that says, again, this is already in statute, that an applicant shall have been a resident of the state for not less than 5 years prior to applying for a refund under this paragraph. Here's the new language. And the applicable property shall be occupied by the owner or an immediate family member of the owner for not less than 9 months of the applicable tax year. That's page 2. Then what we get into page 3, these are the qualifications to be accepted to the program, which basically includes your gross income and assets. And there's amendments on each of those that basically raise the ceiling so that more people would qualify to get accepted for the refund. So on page 3, lines 18, 19, the current language of the statute is that the person's gross income, including total household income, does not exceed the greater of 3/4 of the median gross household income that's currently in statute. We increased that to 125% of the median gross household income. Again, so more people would qualify under the income requirements. And then moving to page 4, there's also, as I said, there's income and there's assets. Currently in statute, it says assets, total household assets cannot exceed $100,000, and we increased that to $150,000. So page 4, line 11, you get to what that refund looks like. Again, so currently it says a refund granted under this paragraph shall not exceed 1/2 of the applicant's prior year's property tax. That's news. And so we increased that up to 90% so that the actual refund that comes back could be a higher amount of money. And then on page 5, we start seeing the county option rules and statutes. So we also, and what we wanted to do here, we need to keep them the same because actually the state program and the county program are the same. The language has been the same in the statute. So we increased that again to 125% of the median gross household income. But something important there on the last page, page 6, also page 6, we increased it to the 90% again, so they match. But I think here's an important one, the final one, page 6, lines 14 through 17. It says the total amount of the refunds under this paragraph, basically the total amount of the refund under the county option shall not exceed 100% of the applicant's prior year's tax property. What we were talking about is that some of the counties that have opted to do this because they completely matched, they qualified under both programs and then they might qualify for more refund than they paid. So we put that sidebar on there. So that's the bill. And I think it's already been moved, so I will talk about the standing committee amendment. This is in regards to, again, the county portion of the statute. And what we did is moved that back from, I'm correct, right? This is the county option, Chairman? And so what we did is so that first the state, then the county, just sort of a fix that we were asked from administration of the program, if you will. So as you'll see, of the amendment, line 14, changing June to September, and line 26, changing September and changing it to December. So I guess with that, I would ask for call for the question on the amendment, unless there's any questions.
Question on Standing Committee Amendment number 1 to House Bill 99. All those in favor signify by saying aye. Aye. Any opposed, no. Okay, Standing Committee Amendment number 1 has been adopted to House Bill 99. Back on the bill, and we do have an additional amendment.
I respectfully withdraw my amendment.
Okay, House Committee of the Whole Amendment number 1 to House Bill 99 has been withdrawn. We're back on the bill.
Thank you. And so I finally want to end with this. We've been getting some emails, and so I just want to address those concerns. So some of the things that were said in emails that we may have received, that starting another tax refund program is cumbersome and it costs administration. Again, I want to reiterate that this is a program that's already in existence. It's already being administered. Of course, there will be an increase in some of the number of applications that qualify. That's the whole point, is that we're trying to reach a few more people with some property tax relief. But it certainly hasn't been the testimony that this would be a large new program or cumbersome. That isn't the testimony, and that's not what would happen here. And then another one that we were getting was, don't do this relief because we want different relief. We want like a lowering of a tax rate or caps. Those are in discussions in committees, in our committee, probably some of yours. Some of those, for example, like, and we're looking at it, might take a constitutional amendment. It could be a long time down the road before, even if we get it passed, there's any relief. This is something that's already in statute. So, you know, we passed this through, increasing that opportunity for some people, and it's immediate, on the ground, ready to go. So it certainly isn't a sky falling, but I wanted to say also, what we're doing is creating lots of tools to put in our toolbox. We're doing a comprehensive look at a bunch of different types of things. It isn't one or the other. We've already, I know a previous speaker or bringer of a bill got some of these questions. We're looking at doing a lot of different things. So it might target this person and this person and this person, and we can hit the most people with the most appropriate tax relief for them. So it's important that we put this tool in our toolbox. And with that, I ask for your aye vote. Stand for questions.
Chairman Washit.
Hey, Mr. Chairman, I apologize if you said it, I missed it, but what does that percentage threshold correlate to in real dollars? What type of family income are we talking about here? 'Cause I think one of the problems we've had with this program in the past is a lot of the people in that income demographic don't own homes. It's the people just above them that are still struggling. They're still lower income, but they're just above the threshold. So I want to make sure that this threshold percentage is capturing a sufficient number of homes that are struggling.
Representative Oakley.
Thank you, Mr. Chair. I'm not sure I understand, so maybe you'll stay, if you'll stay near, but so we can talk about the numbers. I do have some numbers as far as what we're looking at as far as increasing this median income. But I guess, as to your question, if some people don't own property, I don't understand. I mean, this is property tax that we're discussing. So I don't know how it would be relevant. Sorry if that doesn't answer the question. But I would say going to this 125% of median household income, in my opinion, these are some significantly high median household incomes. In my personal opinion, you heard me withdraw an amendment, perhaps too high, but it certainly would increase the amount of people that would qualify.
Representative Davis.
Mr. Chairman, I believe this is just an isolated issue across the state of Wyoming. You know, there's 5 counties that we're having an issue with property taxes. So that leaves 18 counties that don't have an issue with property taxes. In our area, in the last 4 years, we've had an estimate 3% tax increase. Last year in 2021, we had a 4% tax increase in our area. So have we considered this tax cut, the impact upon the services that are reliant upon the revenue that is derived by property taxes? Less funding would be available to the seniors, the fire districts, library districts, conservation districts. The trickle-down effects of that is what I'm concerned with. And then how would we backfill these county coffers in our districts? So I'm opposed to this.
Minority Floor Leader Yin.
Thank you, Mr. Chairman. So I'm the one that brought the budget amendment to put the original property tax refund in the current budget that we have now. So just to explain that, it's a refund program, but all of that money just comes from state funds that we appropriate. So it doesn't take any money away from your counties. The property tax bills are still paid, so they get distributed to your local towns and counties, independent service districts, senior centers, et cetera. And then the general fund monies that we get, we appropriate to the refund program, which we distribute to the folks that apply for the refund program. So it doesn't deprive any of your communities. It's just a program that we fund every once in a while to make sure that we can give people some property tax relief.
Chairman Harshman?
Thank you, Mr. Chairman. And again, this is a refund, and I think is these people have already paid their taxes. This is a refund, so everybody's held whole. It's none of that. And so it's about funding this program. I think we've had this program since 1985, I think, in my brain. It's telling me I might be wrong, and we've generally funded it every year. We didn't for a couple of years, 2018, 19, when we were flat broke. But I want to talk about, Mr. Chairman, that 125% of median household income in each county. It's different. So if you're in Teton County, it's 122,000, 125%. Right now it's 75, but the bill proposes to move it. So if anybody up to 122,000 a year income could make that. But if you're in, let me see if I can find the lowest here, Mr. Chairman. I think it's probably, I'm looking at Hot Springs at 62,000. You make over 62,000 household income, you wouldn't qualify in Hot Springs County. I think I can say those counties, right? We've changed our rules, yeah, for sure. 107,000 in Campbell County, if you make over that. But if you make, another example, Goshen County, if you make under 65,000. So we've tried to expand that a little bit. But I think the real key, the real gatekeeper on all this, folks, we did not change, and that is on page 4, line 14, that the amount of the refund will never be half of the residential liability in your county. That has been in law forever. So that's that part. Then I'll just say the department really did a great job, and so did our local assessors. And you had people with Meals on Wheels distributors distributing this information. It's a pretty straightforward application. And the amount of applications across the state increased dramatically. And so it was very successful. And we heard a lot of stories from people. So what we're trying to do is open this up to a few more folks. We raised the income threshold, and we raised the asset level in the household up as well. And all we did is adjust the timing with the county optional program with the state program to make sure they don't get to do a double on each one. So the state goes first, they report to the county, hey, John Doe in your county already got it, so you're not eligible for this much county, just a little bit or whatever it might be. So that we got to make sure that's taken care of. Again, the program's been in state statute forever. Been highly successful, and I think it will be even more successful. The current director of the Department of Revenue has just done a fantastic job, and it's starting to become part of the culture to help really our elderly and folks who don't make as much money. Okay, thank you, Mr. Chairman.
Representative Storr?
Thank you, Mr. Chairman. I just wanted to add to address the question of property value increases. We've actually seen in the last year, 21 out of 23 counties have seen increases of more than 10%. And that's on top of the year before, which was also rather significant. I believe that all counties did, there were folks in every county that actually applied for the state refund. And there's about 5 counties, I think, now that are looking at adopting the county program as well. So there does seem to be a need out there, and what I like about some of the changes that this bill makes is that by going to 90%, but also focusing on just it equaling half of your tax liability, it actually focuses a lot of the refunds on people that do have lower income. So as you get higher, you only get up to the half, versus if you're below that, you get up to 90%. So I think that's appropriate, and it's targeted at the folks that we want to target. Thank you.
Representative Byron?
Thank you,
Chairman. Just to let everyone know, there was mentioned earlier that, that only a few counties are affected by this, and I imagine this was brought up in many campaigns. 3,085 individual homeowners were approved for this last year in every single one of your counties. So it's not a specific issue with 3 or 4 counties. I would urge you to go back and look and look at the data. I'm happy to provide it, but over 3,000 people applied for this program. Over 4,000, over 3,000 were granted it. So think hard as you decide whether or not to vote aye or nay on this.
Representative Oakley, or?
Thank you. So just to address some of the things that have been said, I know it has been. I'm actually a little surprised at this pushback, since we've discussed so much that we need to, this is an issue that we want to address for our constituents. And this specific bill talks about lower assets, lower income. You know, as a policy decision, if we want to look at lowering that sum, I would be for that. But, and then as far as saying you're opposed to this because you know, when you lower your property taxes, less go to your counties. All of these property tax bills are going to do that. That's what happens. But I would argue this is one of the least impactful because of the way it's set up. And so there's many proposals we'll look at. This seems like an easy one to do. I'd urge you to pass it again if we want to look at lowering that income so we hit less people, but making sure it's targeted. I'm in for that. Vote aye on the bill.
All right, question on the bill being called. All those in favor of Chairman Harshman's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 99 do pass, signify by saying aye. Aye. Any opposed? House Bill 99 has passed the committee of the whole. Mr. Majority Floor Leader.
Thank you, Mr. Chairman. I move the committee of the whole rise and report.
Yep. You've heard the motion. All those in favor of the Majority Floor Leader's motion to rise and report signify by saying aye. Any opposed? That motion does carry.
Let's see. I gotta find my, let me see, where am I? The reading clerk will read the committee of the whole report.
Mr. Speaker, your committee of the whole, having had under consideration bills on general file, begs leave to report as follows. House Bill 128 do pass. House Bill 145 do pass. House Bill 190 do pass amended. House Bill 126 do pass. House Bill 129 failed to pass committee of the whole and was indefinitely postponed. House Bill 121 do pass amended. House Bill 206 failed to pass committee of the whole and was indefinitely postponed. House Bill 172, do pass amended. House Bill 160, do pass amended. House Bill 147, do pass amended. House Bill 119, do pass amended. House Bill 103, do pass. House Bill 185, do pass. House Bill 19, do pass. House Bill 124, do pass. House Bill 99, do pass amended. Representative Olson, Chairman.
Chairman Olson.
I move the adoption of the committee of the whole report.
You have heard the motion. All those in favor say aye. All those opposed, no. The motion carries. Congratulations, Representative Olson. All right. Messages from the Senate. Do we have any of those? No messages from the Senate. Okay, reports from standing committees.
House Bill 156, sponsored by Representative Locke, voter identification limitations, an act relating to elections. Mr. Speaker, your committee number 8, Transportation, Highway, and Military Affairs, to whom is referred House Bill 156, voter identification limitations. Respectful report, same back to the House with the recommendation do pass with the following amendments. Ayes, Representatives Berger, Nemec, Overmueller, O'Hearn, Pendergraft, Smith, Stivar, Wiley. Noes, Representative Brown. Representative Brown, Chairman. House Bill 95, sponsored by Representative Rodriguez Williams, Working Animal Protection Act, an act relating to counties, cities, and towns. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred House Bill 95, Working Animal Protection Act. Respectful report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Allemand, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman. House Bill 100, sponsored by Representative Jennings, Acquisition Value Study, an act relating to property tax. Mr. Speaker, your committee number 3, Revenue, to whom is referred House Bill 100, Acquisition Value Study. Respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Baer, Byron, Harshman, Locke, Northrup, Oakley, Strzok, Swanitzer. Noes, Representative Storer. Representative Harshman, Chairman. House Bill 171, sponsored by Representative Byron. Notice of state land leases and local opportunities, an act relating to state lands. Mr. Speaker, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom is referred House Bill 171, Notice of state land leases and local opportunities. Respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Angelos, Burkhart, Byron, Larson, Newsom, Singh, Storer, Western. Noes, Representative Winter. Representative Newsom, Chairman. House Bill 175, sponsored by Representative Strzok. Excused absence, state fair events, an act relating to student attendance. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom was referred House Bill 175, excused absence, state fair events. Respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Alaman, Allred, Banks, Crago, Davis, Eklund, Slagle, Winter. Noes, Representative Conrad. Representative Eklund, Chairman. House Bill 180, sponsored by Representative Davis. Brucellosis testing notification requirements, an act relating to agriculture. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred House Bill 180, brucellosis testing notification requirements. Respectfully report, same back to the House with a recommendation that do pass with the following amendments. Alaman, Allred, Banks, Conrad. Ayes are Alaman, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman. House Bill 188, sponsored by Representative Winter. Wolf depredation compensation, an act relating to agriculture. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred House Bill 188. Wolf depredation compensation. Respectful report, same back to the House with the recommendation that it do pass with the following amendments. Representatives Ayes, Representatives Alaman, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman. House Bill 200, sponsored by Representative Northrup, an act relating to game and fish. Mr. Speaker, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom was referred House Bill 200, non-resident hunting licenses, application fees. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Burkhart, Byron, Larson, Newsom, Singh, Storer, Winter. Noes, Representatives Angelos and Western. Representative Newsom, Chairman. House Bill 229, sponsored by Representative Larson, J.T., Electronic Payment of Sales and Use Taxes, an act relating to sales and use taxes. Mr. Speaker, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom is referred House Bill 229, Electronic Payment of Sales and Use Taxes, respectfully reports same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Berger, Brown, Nemick, Obermueller, O'Hearn, Pendergraft, Smith, Wiley. Noes, Representative Stivar. Representative Brown, Chairman. House Bill 287, sponsored by Representative Harshman, Gaming Districts and Amendments, an act relating to gaming. Mr. Speaker, your Committee Number 3, Revenue, to whom is referred House Bill 287, Gaming Districts and Amendments, respectfully reports same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Byron, Harshman, Northrup, Oakley, Swanitzer. Noes, Representatives Bear, Locke, Storer, Strock. Representative Harshman, Chairman.
Re-referrals, Chairman Brown.
Thank you, Mr. Speaker. I need to re-refer House Bill 229 to your Committee Number 2 Appropriations.
Seeing no objection, House Bill 229 is re-referred to Committee Number 2 Appropriations. Chairman Eklund, I believe you have a re-referral.
I believe I've finished all my referrals. You want to refresh my memory?
I'm hearing that maybe House Bill 188 needs to have that done again.
Okay, we'll do it again. Your Committee Number 5, Agriculture, would like to re-refer House Bill 188, wolf deprivation, to Committee Number 2, Appropriations.
Seeing no objection, House Bill 188 is re-referred to Committee Number 2 Appropriations. The bill had to be read in before we could re-refer it. Vice Chair Oakley, in the absence of Chairman Harshman, I believe you have, your committee has a re-referral of House Bill 100.
Thank you, Mr. Speaker. I would like to re-refer House Bill 100 to Committee Number 2.
Seeing no objection, House Bill 100 is re-referred to Committee Number 2 Appropriations. Chief, does that clear the deck? All right, Mr. Majority Floor Leader.
Mr. Speaker, I move the House adjourn until 10 a.m. February 1st, 2023.
Committee announcements, Chairman Zwanitzer.
Thank you, Mr. Speaker. Your Committee Number 10, Labor, Health, and Social Services, will meet at 7:30 tomorrow in EO3 to hear the following 4 bills. First up, we're going to try to do pilot student loan payments, House Bill 202, then House Bill 127, Healthcare Facilities, House Bill 263, Restoration of Voting Rights, and House Bill 261, Breach of the Peace within a Healthcare Facility.
Chairman Burkhart.
Thank you, Mr. Speaker. Your Committee Number 9, Minerals, Business, and Economic Development, will meet tomorrow morning at 8 a.m. in Capitol Extension Room E5 to consider House Bills 239, 286, 268, and if there is time, 253.
Chairman Northrup.
Thank you.
Chairman Washit.
Thank you, Mr. Speaker. Your Committee Number 1 will be meeting tomorrow morning at 8 o'clock in our normal meeting room to hear House Bill 152. There will be no more further public comment, but the committee will work the bill. And then House Bill 212, Statutory Standing Committees and Federal Review, House Bill 231, Public Defender Funding Amendments, and House Bill 241, Prohibiting Sexual Relations with Persons in Custody. And there were 2 emails sent out on this meeting. One of those was deleted or canceled, but the meeting is still scheduled, so 8 o'clock tomorrow morning.
Chairman Olson.
Your committee number 7, House Corporations, Elections, and Political Subdivisions, will meet tomorrow upon noon recess in E005 to consider the following 4 bills: House Bill 211, ballot harvesting; House Bill 164, legal notice publication on websites; House Bill 279, voter identification requirements; and House Bill 242, consumer merchandise packaging regulation prohibitions. Thank you, Mr. Speaker.
Chairman Northrup.
Thank you, Mr. Speaker. Your committee number 4, Education, will meet upon noon recess tomorrow. We're going to do House Bill 223, which is Wyoming Preschool Provider Grants, House Bill 177, expulsion for possession of a deadly weapon, and House Bill 192, Education K-12 food service.
Chairman Nicholas.
Thank you, Mr. Speaker. So your House Appropriations will meet at 7:30 tomorrow morning to hear House Bill 195, and we'll try to get House Bill 100 re-referral kicked out as well. And your House Bill your appropriations will meet on adjournment immediately hereafter for re-referrals of House Bill 88 and 116. And so if those are your bills, please come on up to and also further work on Joint Resolution 6 and 7. And ladies and gentlemen, just a reminder, under Rule 14-1, all of the budget amendments that have been submitted by 5 o'clock and that have not been approved, you have to approve them 2 hours before 10 o'clock, which is basically 8 o'clock tomorrow morning. There are currently approximately 67 amendments, and so we may have a busy day tomorrow to knock those out. So, but also your approval will be needed before 8 o'clock.
Any other announcements? You have heard the majority floor leader's motion. All those in favor say aye. All those opposed, no. Motion carries. The House is adjourned until 10 a.m. tomorrow, February 1st, 2023.